exciting. There's over 700 people with reminders on, so I'm assuming everybody's going to continue to find their way to the chat. It's going to be an exciting night. I mean, this is going to be really anticipated filing from John Durham. For those that haven't been following the case that much, this is the filing that Durham's going to make in opposition to what the defense filed. It's all about the motion to compel documents from Fusion GPS, Rodney Joffe, and others. And what the issue is that Rodney Joffe, the Clinton campaign, Fusion GPS are asserting attorney-client privilege and in other cases work client privilege over a large set of documents. There's over 1,400 emails that Fusion GPS has that are being withheld or are redacted. There's additional emails between Rodney Joffe and Fusion GPS personnel that the Clinton campaign is attempting to assert privilege over. And tonight is going to be the filing in response to the final filing on this issue from John Durham. And this is, if he wants to build a conspiracy case, if he wants to go any further, this is going to be the most important filing that he does. And there's really no incentive to hold anything back. So he's immunized David Dagan. He's immunized, we believe, Laura Sego. And we might see something from them in this filing. But any evidence that he has that's tying all these actors together in the joint venture conspiracy that he's alleging, we're probably going to get a little bit of insight into that tonight. So while we wait for that, I mean, there's obviously a lot of issues we can talk through. Let me say first, I mean, thank you to everybody for coming out. I really appreciate it. I saw Mike Cernovich tweet this out. I appreciate that, Mike. I don't know if you listen to these, but I appreciate that. Sean Davis, I saw, tweeted this out as well. Thank you to him. And I mean, what this is, we're basically an independent group. I wouldn't even say it's a group, but it's this independent consortium of researchers that have been looking into Russiagate over the past several years. And it really started with a guy, an anonymous handle under Undercover Huber. That's where I first noticed it. And this was really back in 2017. And what Undercover Huber was tweeting about did not line up with what the media was reporting at all. And I first took notice of that, obviously, and I followed it, but I didn't know how much weight to put into that. And then as events started unraveling, you find out that he's right. And then I picked up on other researchers. Fool Nelson was right in the mix from early on. Walk of Fire, Hans, Stephen McIntyre. I mean, these are just brilliant guys. And the work that they were able to do, analyzing documents, declassified documents, and reports, they really started framing this up. And it completely did a 180 with the narrative. I mean, not only was there no collusion, but there's FISA abuse. There's there's a conspiracy developing on the Clinton side where Fusion GPS, Clinton, Joffe, and others, made all this up. They manufactured evidence and submitted it to the FBI to dirty up Trump and to not only to damage his campaign, but to hurt his presidency. And, through pursuing FOIAs, there's several of us that do it. We've been able to obtain some really important documents. Just analyzing the reports and the declassified documents that are out there. I mean, there's a lot there, and you don't hear about it in the media. Even in conservative news, you don't see anybody breaking it down into the minutia. And it's only when you get into the minutia that you really understand how bad this was. So we're waiting on John Durham to submit this filing tonight. We did have a filing earlier today, and there was also a big story from Margot Cleveland on Friday. And for those that haven't been following this, I'm just going to tee everything up. I mean, we have a little bit of time to kill. So if you haven't been following this, here's a couple bullet points. And then MB, I think I'll throw it to you here in a couple minutes. So a lot of people don't understand what this case is about if they haven't been following it. And like I said, the media's not covering the minutia. They're not covering the details of what happened. So Georgia Tech obtained a contract back in 2016 through the Department of Defense, and specifically through DARPA, which is an advanced research sub-agency of the Department of Defense. And what this program was to do was to look at cyber actors, cyber attacks specifically, and start looking at attribution. And they needed data to do this. So Georgia Tech bought data through a company called Neustar. And we have a few characters that were kind of outlined in the indictment of Michael Sussman. And the first is Rodney Joffe. Rodney Joffe is a powerful executive at Neustar, and then he has a slew of internet companies. And he's an entrepreneur, and he's got several of them that I want to at least briefly mention. The first would be Packet Forensics. So this entity of Rodney Joffe sells surveillance equipment to basically all the powerful intelligence and law enforcement entities of the U.S. government. And one of those other entities, or at least another association, is a company called Vostrom. And in between there, we get an affiliation from a gentleman named Raymond Salino. And you can find some stories about Raymond Salino. Most prominently, he was associated with a company called Global Resource Systems. And on inauguration day of Biden's first day in office, there's a story out there that you can find where the Department of Defense transferred a large block of, I believe, 176 million IP addresses to this brand new startup company. And that company is registered to Raymond Salino. So that's where his name might be a little bit familiar to you. But Salino used a lawyer called Martin Janol. And Martin Janol has a much longer history with Rodney Joffe. And that seems to imply some degree of association there, because Martin Janol is a Beverly Hills lawyer. There's really no discernible relationship between the two other than Rodney Joffe. So that's something that's a little bit scary when you get into the story, and just knowing that there's this relationship with the Department of Defense is a little bit concerning, right? So what ends up happening is we found Raymond Salino's name in the registration documents as Zetalytics. And Zetalytics comes in the story because that is the company of April Lorenzen. She is originator one in the indictment. She provided the data that alleged this secret communications channel between Trump and Putin. And this channel, there's a few different iterations of the allegations, but basically there were pings that were picked up, and there was allegations that there was some type of encryption pattern that you could discern a communication type channel. And this supposedly went through Spectrum Health, which is a hospital in West Michigan. And it's a really convoluted story. I don't want to get into that too much. But Rodney Joffe basically ended up with this data from April Lorenzen, and then he got into contact with two researchers at Georgia Tech that were doing this enhanced attribution program on behalf of the Department of Defense. And he got in contact with a gentleman named Manos Antonikakis and David Dagan. And that is researcher one and researcher two, respectively, out of the indictment of Michael Sussman. And together they began crafting a narrative. And there's some pretty damning text messages that are alluded to in the indictment where they're going to find the data that supports an inference of a communications channel existing. So that's pretty damning evidence if they don't even necessarily believe that the communications channel actually existed, because then they went ahead and submitted that through Michael Sussman to the FBI. And now what Michael Sussman is charged for is a very simple 1001 count of lying to the FBI. And all he said was that he was not representing the client. But when you start getting into the details of this, you realize, as John Durham has alleged and outlined, that there is a joint venture conspiracy. Now, it's not a criminal conspiracy yet that he's alleging, but there's multiple parties, being the Clinton campaign, Fusion GPS, Rodney Joffe, that are all working towards a common goal. And because they're working towards a common goal, that's a joint venture. And Michael Sussman took these allegations on behalf of that joint venture to the FBI, and he stated very clearly he had no client. And we have a text message now where that's no longer even in question. There's no doubt that he did lie to the FBI. The only question out there is it material? And what John Durham is trying to get tonight in his filing that we're expecting is a number of documents that he wants to submit to the judge for an in-camera review. That means they're going to take these documents. They're say, John Durham, I don't want the documents right now. Okay, I don't know if these privilege claims are valid or not. So, Judge, I want you to take these documents and perform and review these documents in your chambers, and you tell me, are these privilege claims valid or are they not? And if they're not valid, and a lot of legal experts say there's no way in hell that the privilege claims are valid, then John Durham's going to get a very large number of documents. He's also going to get a lot of unredacted copies of documents that he already has. And that's going to open up a whole lot of different avenues for him to investigate if he wants to actually pursue a criminal conspiracy. So that's why tonight's filing is so important. We have a lot of different underlying facts. If you've been following this for a while, you may have picked up that Rodney Joffe and these researchers had a data stream straight from the White House. And some left-wing outlets didn't get this quite right. They kind of jumped all over people that were looking at this and said, well, okay, it was Obama. But we actually just got a filing, I think it was last week, and there's no more question. It actually was before Trump was inaugurated, but also after Trump was inaugurated. So they were spying on the president. There's really no question about that. And getting these data streams from Trump's apartment complex, from the White House itself, and MB, I don't know if you want to pick up and maybe talk a little bit about what DNS data is. I'll take a break here for a second. All right, I'll keep ripping. MB, whenever you come back, let me know. Or Sean, I don't know if you have any thoughts that you want to share as far as DNS. I know you have a little bit of expertise as well.
I wouldn't say an expertise in DNS, but DNS is basically it's a domain name resolution service that if you type in, God forbid, CNN.com in your browser, that basically needs to resolve to an IP address. So there are DNS servers around the world that maintain an IP address that's associated with that domain. So those are the logs that we're talking about. And it seems that one of Joffe's companies has a sensitive contract to provide DNS resolution services to the White House. So by looking at those logs, you can determine what websites somebody is visiting, which is a pretty concerning development that someone, this is what I'm getting from those filings, that they're leveraging that data to try and dig up some kind of inference on Trump and a relationship with Russia. That's what I got from the filings, and that to me is very concerning.
Yeah, I appreciate that. Thanks for jumping in there. MB, I don't know if you're back. I don't know if you have any comments.
I think I'm back. Yeah.
There you go.
Sorry about that, everybody. Twitter kind of freaked out on me. So Elon, fix this shit. Anyway, so just to give a quick, there's a lot of people have a lot of questions about DNS, and I'm going to start out again by saying I'm not an expert by any means, but I can give a kind of to follow up on Sean, just a thumbnail of what we're looking at here. And you got to consider that it's metadata. It's not, we're not talking about reading people's emails. We're not talking about listening to their conversations. It's going to be, a much more general type of thing. And typically DNS is really useful when you have a bunch of it, when it's a collection and you can statistically analyze it. So what we're talking about here is exactly like Sean said, you're monitoring what computer is talking to another computer, and how it bounces around the internet to get there is sort of the infrastructure of the internet. And Rodney Joffe and some of these people, basically they have companies that control and create logs and deal with that. So it's a very powerful position when you think about it, because if you know who everybody else is talking to, who they're friends with, who, that can give you a great deal of information about who they are and what they're up to, basically. So I guess the surveillance aspect of this was another thing that we've all been really concerned about. The FISA courts come into this in the bigger picture, but government surveillance is that was one of the reasons I got into this. And I think a lot of people are really concerned with it. And this was just a surprise to people that this thing that, your average person probably didn't know exist, the DNS system, is actually a really powerful way to surveil people, especially, if you're going to go in and cherry pick and do what we think Jaffe and some of these other people did by just, it's very easy to go in and just, if you know what you're looking for and you're only looking for that with no context, you can tell a story. You can create a narrative that is potentially very incriminating. And that's exactly what happened here is, we're talking about a Russian bank here. We're not talking about, we're not even talking about the KGB or something. We're talking about some tangentially associated Trump servers that he didn't even control were pinging off a Russian bank. And, to weave that into a tale of backdoor conspiracies and that's the way they were communicating. When you think about it at this point, it's just ridiculous. It's just, why would that be the way they chose to communicate? I mean, it doesn't make any sense. It never really made any sense, but
absolutely.
I guess at that time and place, people were willing to entertain just about anything if it was, going to get Trump out of the picture.
Yeah, and I think we saw just last week the CIA findings that John Durham reported. Apparently, the CIA concluded that these pings were user-created, which certainly would seem to suggest that there's fraud involved, right? And I always circle back to this point when we talk about this. The pings, as far as we are aware, they began May 4th, 2016. And they continued into September. I believe it was September 23rd that they might have stopped, maybe September 26th. And the narrative that came out, and this was pushed by Franklin Foer in his first article about this in October, the narrative that they put out was that the ping stopped in September after Eric Lichtblau reached out to Alpha Bank representatives. And what they suggested was, they were trying to hide this communications channel or whatever, that, they realized people were onto them. So they stopped, which is ridiculous. There's just no truth to that, because what I think is the case, on September 19th, 2016, Sussman brought these allegations to James Baker. Now, what Franklin Foer says is that September 21st is when Eric Lichtblau reached out to Alpha Bank, and then the ping stopped soon after. Well, that's convenient for their narrative. But what I think is the case is once they gave it to the FBI was going to start an investigation, and they needed a reason to explain why the pings had stopped, because if the FBI is looking for those pings, they're not going to be able to see them because they're fake, they're fabricated. And I think that's really what happened. Now, it becomes really unusual because in February, when Jaffe and Sussman realized that the FBI has debunked this, they're not even interested in the story anymore. They come up with an idea, and I think it's just out of desperation, pure desperation. They want to take these allegations to the CIA, and magically, within days of this meeting, the pings start again, and they continue for another couple weeks. So that opens up the inference. A very logical inference that not only are the pings manufactured or fabricated, but Rodney Jaffe probably had a role in that fabrication process. That's the strongest explanation for why the pings would start or stop in those time periods. Would be fabrication being very close to Rodney Jaffe. And there's a couple theories out there. There's one theory that I sort of support, is that there's two groups. So there's one group of actors that are involved with actually spoofing or fabricating these pings. And then there might be a second group that involves researchers actually doing the analysis. And this would be the group that Manos and David might fall into. But there's obviously a lot of questions out there, and I'm just offering that up for speculation. I also want to circle back to one point. So as it relates to this DNS and this data that's being collected by Rodney Jaffe on Trump, and obviously all these different locations, the Trump apartments, the White House. We're talking about DNS data there, but also even back into the summer of 2016, Joffe was using non-public access to various databases to collect a whole lot of data on Trump associates. And there's one article, and I kind of threw this out last night. They submitted a 5-page dossier, if you will, in late July to early August that started making its way through the FBI. And it actually made its way to Strzok pretty early in August. But then about 6 weeks after that, McCabe, assistant director of the FBI, shuts down a former CHS that's bringing them this data, bringing them this list of Trump associates. And there's this piece by Paul Sperry out there that somebody shared with me. And Sperry, and I've not independently confirmed this, but Sperry's reporting that this 5-page dossier includes Michael Flynn, Paul Manafort, George Papadopoulos, and Carter Page. And, Durham's finally last week just said, well, there's several Trump associates. So if we're only talking about 6 or 7 people and 4 of them are targets for the FBI, that opens up a question that has to be asked is there a feedback loop from the FBI to Rodney Joffe and Michael Sussman that prompt them to include these individuals in their analysis in some way? As speculation, I don't like to put that out there lightly, but if those 2 individuals are on the list, as Sperry reported, and they're 4 of maybe 6 or 7 people, there's really no other explanation, because Papadopoulos and Michael Flynn are not in the dossier. They're not in the Steele dossier at all. So if they're in Joffe's list, that's really the strongest inference that I would make, is that somehow they knew that the FBI needed data. And that opens up the question of, did McCabe shut down that former CHS because it was too unusual and too alarming that he was getting data so central and so specific to open cases that they had in Crossfire Hurricane at the time? And we'll just have to keep an eye on that. I don't even know if we can speculate on that any further at this point, but that'll be an open question, I think, for some time in the future.
I think,
go ahead.
Just jump in real quick. I think that's a really, really important point, that you're going to hear a lot of people that are trying to make light of this whole situation, saying, look, these are, technical experts that came up with this information and they're trying to get it to the FBI out of, being patriots. And that's just not how things went down. This was actually information like that of who to search for, the names, the list of names was come up with in an office somewhere and we're just starting to get more details on when these meetings happened. But you had Sussman, who was a lawyer that worked for Perkins Coie, that worked for the DNC. You had Mark Elias, that was the same. And you had Joffe sitting in these people sitting in an office having discussions, and we don't know where they're getting necessarily all the information. And hopefully we'll find out some more about that, because apparently there's someone who's going to testify that was in a lot of those meetings. But they made a list of people's names, of IP addresses, and they took that and took it to the research experts and said, go find dirt on these people, on these entities, basically. So this wasn't an organic thing that bubbled up of, oh geez, this is really bad, the Russians are doing something, we found this evidence. It's absolutely the opposite. It's go find dirt on these guys and do whatever you have to do, cherry pick, just go find it, and then we'll do the rest. We'll get it to the authorities, we'll put it in the newspapers, in the media. So that's kind of the way you got to look at this, and I think that's super important.
That's good stuff. Hey, Sean, do you have something to say?
Yeah, I just wanted to basically give a synopsis of what spoofing is, basically, with DNS, because when we talk about these communications being fabricated, a good analogy would basically be that you want to create the impression that 2 people are communicating with each other. So what you do is you write a letter, like an actual physical letter that you would mail in the mail. And on the to address, you write one person, and on the reply address, you write the other. You put it in the mail, it goes through the post office, say they record all the to and from letters that are coming through. The letter will still get there, and basically that is recorded. And even though you will not get a reply back, the other person might. So what happened in 2017 is after Alpha Bank saw the 2016 articles, they installed security software that would alert them if there were any DNS requests coming back to them that they did not generate, which is exactly what happened. So in 2017, Alpha Bank found that they were spoofing, somebody was spoofing these requests using their domain name. And they came out with a press release, and there's no way for them to know who did it without basically huge surveillance systems that belong to the government and things like that. But that's how you would end up with the same data in April Lorenzen's logs or the Georgia Tech researchers' logs. That's how it would look authentic with it being fabricated. So when we talk about the logs being fabricated, it's not so much like the text files that you have that you pull off the server. It's that's the process. That's what spoofing is. So I hope that makes sense to people.
Yeah, thank you for that.
And we talked a lot about that in the last week because I want to be careful with what Durham is putting out about the CIA, because I do think that we might be out a little bit over our skis saying that the CIA confirmed that these things were user created. You could read that as the files were user created and had some sort of human intervention, which is true. And so these were text files, CSV files that eventually made its way to the FBI and CIA. And like Sean just said, that's fine. They were obviously exported from some kind of a program somewhere online. It's really where that data came from that is what's important, and how that was aggregated and what the sources were. But the point being, and this was pointed out from the very beginning by some expert tech people, like Rob Graham was one on top of it, that you can fake this stuff very easily if you're just getting the output of these log files, because you don't know where it came from. I mean, they're text files. Someone could go in there by hand and they could, just make changes. There's no reason to think that they did that or they didn't. But the point being, you can't verify any of it. So it's garbage in the sense that without any chain of custody, we have no idea where this stuff came from, who had access to making changes. That is kind of the key here. Is anybody that looks at this stuff and goes, well, it's clearly just, there's proof positive this is a smoking gun. It's absolutely not.
Hey, MB, I just wanted to let you know that I don't know if you listened to the hearing, but the Durham attorney, I forget who it was, I think it was DeFilippis, he actually said that the user, it was user created, that the CIA analyst that wrote that memorandum did believe that it was user created, the data. Because the defense attorney for Sussman mentioned that in the hearing last week, and then in follow up, that's what DeFilippis stated. So I think we do have confirmation that at least that CIA analyst believed himself. Like, his belief obviously might not be definite proof, but they believe that it was manufactured data.
I'm not disputing that, but I think that the defense attorney did make a good point that it depends on what you're talking about. It depends on how you're kind of putting a slant on it, and that'll come out. I mean, this stuff we're gonna find out a lot more. But I would just say, don't get too excited thinking that the CIA 100% debunked this stuff, because I think that's not really established at this point. I think it probably was spoofed, but I don't know that it was spoofed in a way that you could just look at it very quickly and come up with that conclusion. You could look at it very quickly and say, this is not definitive. This is I can't make a judgment one way or the other, because there's no way to tell where this stuff came from. There's no way to verify any of it.
Well, I think one of the points that they also made was that the data was actually incomplete. And I think that was actually the conclusion of the FBI analysts that might have looked at it, where anybody that was saying that it supported a communications channel was wrong, because the data wasn't even complete to make an analysis from. So I think the CIA looked at that and said, well, that at least the logs are user created. And then the FBI didn't necessarily have a firm conclusion either way, other than saying that the data was incomplete in itself. So that seems pretty damning. I mean, from DNS experts to submit data that's not even complete. Like you can't say that that's not suspicious. So.
And when you take a step back, I mean, the entire hypothesis that someone technically competent enough to set up a covert communication channel would do so using the domain names of that organization is so ridiculous that it doesn't, I honestly don't know how this got past the drawing board with Lorenzen and Jaffe and anyone else involved, because there are about 1,000 different ways to communicate over the internet with some amount of security and anonymity, and that is not one of them. So this is the thing about the Alpha Bank case, is that everyone looked at it, raised their eyebrows and said, that doesn't make any sense. And then it kind of went off the radar in the Russiagate saga, at least from my perspective. And I don't know, Undead or MB, if you feel the same way, but this was kind of a curiosity that went away, and everything else was about the Steele dossier and the FISAs and, even Papadopoulos. And this, to my mind, just came back because apparently it was the way that Durham got a foothold here.
Yeah, I think that's exactly right. I mean, this was thought to be a very small piece of Russiagate. And then we find out later that Rodney Jaffe is, he's got deep ties to all the U.S. intelligence and law enforcement entities. He personally advised President Obama numerous times on cybersecurity issues. There's dozens of pages of documents that I know exist relating to communications and meetings between Jaffe and President Obama. And, it's just very unusual. I think that's a great point. I mean, for these guys to come up with something so dumb on its face. I mean, these servers are not even controlled by Trump. And then to assert that this would be the way that a billionaire would try to communicate is just ridiculous. Like, there's so many encrypted communications out there already. But, a billionaire, just take a jet and go speak to whoever you want to speak to. I mean, it's ridiculous on its face. And then I think the inclusion of Spectrum Health in that is just insane. I mean, we haven't even heard much from Spectrum Health. I don't think they even issue press statements or anything on it, because it's so ridiculous that nobody in Michigan gives it any credence whatsoever. It's just so laughable because it's just a hospital chain. The DeVosses do not have any ownership stake of it. The DeVosses are incredibly generous philanthropists. They give a lot of money to a lot of different companies, and there's a lot of DeVosses out there. So they stick a DeVos on the board, and then to try to weave that into a narrative of, the DeVosses are going to be the ones that help Trump communicate with Putin. I mean, it's just laughably insane. And there's so many indications of desperation. The original idea is insane, but then to try to take that to the CIA after President Trump is in office is so desperate and so crazy on its face. But then, a couple years later, I think it was 2018, that they went back to the New Yorker and had another article printed out, and I think that drove it back into the conversation. I think Maddow at least did a couple shows on that again in 2018, and this had been long debunked. I mean, that the FBI had shut this down by February 2017. They looked at this and they're like, no, there's something so wrong that it doesn't support the conclusions. And we see these white papers now, and this white paper that Sussman submitted is just like the Steele dossier. I mean, it's just better written. It's very high-level background information. It names a bunch of characters. It is sort of like a Wikipedia search. I think the Sussman attorneys described it as something like that. But the way it's written, if Sussman could actually write, if he was technically gifted or maybe more inclined towards academia, I mean, this would be what Steele would write. And for them not to connect that to what Steele was doing, there's so many questions out there. I think that's something I say too much, but it's true. I don't know how the FBI didn't get that and immediately connect that to what Steele was doing.
Yeah, not to mention 10 days before Sussman gave this information to the FBI, Strzok himself got a memo from the CIA saying this whole thing is cooked up by Hillary Clinton to distract from her email campaign. So from her email issues with her private server. So they had fair warning. We only found out that in retrospect in 2020, but.
Yeah, that's exactly right. And John Ratcliffe continues to allude to a trove of still classified documents that are going to be damning, and they are alleged to speak to what people knew during this time, and it sounds like there's more than just this memo that warned of Hillary Clinton, planning all this out. So we'll see. I don't know if we'll ever get those documents, but I sure hope we do. Hey, Fool Nelson, how you doing? Hey, Willie, I saw you're speaking now. I don't know if you have any thoughts you want to share. I know we have the one filing from earlier today we can kind of speak to a little bit, I think, and then we might want to. Well, I guess we'll take some questions while we wait. I expect Durham to have this filing. It could be any moment now. He has been making these filings pretty late at night, which is unfortunate. I kind of expected him to have this out earlier tonight because there is no follow-up action. So I don't know if he's just avoiding the media primetime hours or what the case is, but we're going to wait as long as it takes. I'll be here at least till 1:30 in the morning, and we should get a filing from John Durham. So, hey, Willie, I don't know if you have any thoughts, if you wanted to jump in.
Oh, sorry. No thoughts yet. I don't know why I actually requested. Probably just to post memes in the space above.
Okay.
Yeah, but one thing is that the DNS lookups, they're not pings. That's a thing which Twitter's died, I think. Yeah, they're not pings. Pings are a separate type of, is it TCMP lookup or something? And so when we say pings, that's a specific thing in
fair enough
in computer thing.
Yeah, that's sorry.
Hey, Ryan, let me amplify on that a little bit. So,
yeah, go ahead.
Well, I wanted to make clear while you guys were talking about DNS lookup and stuff that a DNS lookup is not a establishment of communications to the second party. You're just looking up their address. So there's no evidence that there were any back and forth communications between one entity and the other.
That is right. And the data set I think that we have, it's all incoming pings. These are alleged to be incoming pings to the Trump server from Alpha Bank and from Spectrum Health, which is also pretty unusual. So
yeah, that's one thing. Oh, go ahead.
I was just going to say one of the things that could lead someone like the CIA to classify or to describe the data as incomplete is if they only had a bunch of DNS replies but not a bunch of DNS requests. And it would raise a lot of questions, I think, in any analyst's mind if they got a list of DNS replies but weren't supplied the requests.
Well, there's one point, and maybe one of you can help me clarify this, because there's a question that I've had is, this was originally a marketing server that was set up to push out emails on behalf of the Trump hotel chain. So this was a third-party server, and my understanding was that it was configured for outgoing emails only. I mean, there's no reason to have incoming emails set up for a spam marketing server. So I don't know if any of you can speak to if that's typical, where it would only be outgoing emails, and does that necessitate a configuration change to allow these incoming DNS lookups, or is that like a separate function?
DNS has nothing to do with either party, other than what its actual IP address is. DNS is just looking up something in a directory. It depends on where they originate and where they go to. So, to get to your other point real quick, while I was on top of my head, is that having an email server configured for outbound only is not unusual, especially for a what do they call it, a CMS or a management email marketing management server. So what it does is it eliminates any kind of overhead with spam that comes in the server, because if you have an email server out there, it's listening on a certain port, and could get hammered if if somebody wanted to denial of service it or something like that, could affect operations. So they just keep it closed and don't accept any incoming connections. But I forgot, I lost my train of thought. So if sometimes now, so there's different instances where emails will do a kind of a verification, but that will be a lookup of itself. That'll be a separate DNS lookup. It's a different type of DNS record that will be looked up. So if I send an email to you, just say, for instance, we've already done the handshaking, I send an email to you, then your email server could be configured to verify that the email domain is valid, has a valid record for it, because you could spoof those all day long and send spam as any domain that you wanted to.
Yeah, it's good context. I appreciate that. JH, I don't know if you had anything you wanted to share. I saw you requested to speak, and I didn't know if you.
No, I just said it. CIA could classify something as incomplete data when it's DNS if they're only supplied a list of the DNS responses, but not the DNS requests.
Part of the problem is that they obviously didn't have access to the Alpha Bank servers, and I think they were resolving their own DNS, so they're just not going to have a good chunk of what they might have if it was something you could subpoena or just have a hold of natively. And by the way, I put up in the nest up there is a link to a real technical explanation for why the Alpha thing was debunked. If you really want to dig into it and get into the technical details.
Yeah, appreciate that. I do want to get into Margot's piece from Friday, but I see we have a couple questions, so we can start with those, and should get a filing from John Durham at any second now, hopefully. So, Daniel, I just added you to the chat. I don't know if you have a question or comment. Go ahead. Hey, Daniel, do you have a question or comment?
Yeah, can you hear me now? Oh, I'm
Yeah,
sorry about
how's it
that.
going?
Hey, my question is really simple. I just wonder, was there any kind of conflict with this judge to recuse himself?
Not that I'm aware of. It's obviously can be difficult to get a lawyer, given all the different affiliations with Trump and Clinton and everything else. But I'm not aware of anything with this judge.
Oh, because I read a couple articles today that stated kind of there's pretty deep ties with Sussman. He was a colleague before and all this.
I'm not aware of that. It's certainly possible. I mean, it's just going to be the nature of the beast when you're working in Washington D.C. and you got a prominent, lawyer for the DNC. Chances are, they're going to be aware of who he is because he's probably been in their courtroom before.
Got it. Well, thank you for my question. I appreciate it.
Yeah, thank you. I'll take one more question and then might talk about Margot's piece. Hey, Biden. How's it going? Sorry. Hey, Biden, how's it going? Oh. I think we lost you. Well, I'll go ahead and get into Margot Cleveland's piece from, I think it was Friday, because that's that's going to be the next layer of this investigation, I think, is through FOIA, we actually obtained documents that show that Manos and Tanakakis, or at least David Dagan, assisted in some fashion with Special Counsel Mueller. And specifically, they provided documents, analysis, and a white paper on DNC hack attribution to the Department of Justice. They also did analysis on Fancy Bear. They did analysis on Cozy Bear. They also did analysis on cryptocurrency transactions, which I think comes into play for the purchase of domains, which is sort of an Easter egg buried into the indictment. And what Mueller had put out is that these GRU operatives had purchased domains and some equipment, I think, with cryptocurrency. So I think that's the tie-in there. So that's obviously pretty interesting, just knowing that somehow, these group of people that are tied to allegations of spoofing and fabrication of evidence for the Alpha Bank case are in some fashion involved with Special Counsel Mueller. And that's pretty explicit in the emails that we've gotten. There's no question that they did provide evidence and data and analysis to Special Counsel Robert Mueller. And we have other emails that we've had for some time where, Manos and David Dagan, or at least Manos, they're more worried about being tied to attribution. And we've been trying to figure out exactly what they mean by attribution, because that might be, we don't know if that's in 2016 when the hack occurred, or if that came a little bit later as it relates to attributing the hack of the DNC, specifically the 12 GRU operatives that were indicted by Mueller. But that's what Manos was more concerned about. Now, when Special Counsel Durham reached out to him in 2020, we have these FOIA documents that indicate that's what Manos was concerned about. And he asked specifically what Georgia Tech was going to do to offer him protection once that came out. He wasn't concerned about being tied to fabricated evidence around the Alpha Bank communications server allegations. He was concerned about being tied to attribution. So that tells me that, he is involved in some way significantly with the DNC hack analysis, and that's not to state that there's something nefarious about it, but it is highly unusual. It's just to have the proximity of somebody tied to spoofing or potentially criminal misconduct if it is proven. And then on the other side, he's helping Special Counsel Mueller, and he, if that's to be legitimate work that he did, it's just another unusual aspect to an extremely bizarre story. So, MB, I don't know if you have any thoughts or questions on that, or if anybody has any thoughts on that story, or Manos or David or anything like that. We can talk about that for a while if anybody wants to. Or yeah, I can go back to questions, but yeah, go ahead.
Yeah, the DARPA thing is obviously going to be, I think it's important no matter what. We've kind of asked the lawyers about this, and no one really has a definitive answer. But when you have the military involved in domestic surveillance, it's a real gray area, because they can be looking at Russians and Romanian hackers and all these other things, but that's a real thin line between that and you're just surveilling Americans. And obviously, demonstrably, that can happen. That line can be crossed. It has been crossed. And I would guess that, if these guys are clever, and you think they're pretty smart guys, they're reasonably savvy, that it occurred to them at some point that, wow, we could be, doing something that puts us on the cover of the New York Times and maybe lands us in jail. All this alpha stuff aside, this is just what they were working on in general. It was flying under the radar screen for so long, but I would think that at some point they'd have to go, we don't want to be the next FISA scandal. We don't want to be the next, Watergate, whatever it's going to be. And turns out they might be. But I do think that is probably, it's funny because these guys kind of protest too much, because a lot of them are talking about, oh no, if this gets out, the Russians are going to know my name, and I'm going to be on Putin's target list. And even, there's even a guy that was working at the the DNI that was sort of like, oh, I'm worried about my safety. And it's like, yeah, I don't know if I really believe you're worried about your physical safety from the Russians, but I do believe that you don't want to be the poster boy for the surveillance state. And I think that these guys were really concerned about that.
Well, it speaks to a really bizarre relationship, I think, between the FBI, the Department of Justice, and DARPA, which doesn't make sense to me because it's not just limited to Russiagate, and it's not just limited to cases that seem to have a foreign aspect. You know, the Department of Justice and the FBI are asking for assistance from DARPA inside the Department of Defense on domestic investigations, and that's so many red flags. And it's like, DARPA is supplanting what I always thought the FBI did, right? If there's a cyber aspect, there was a terrorist attack. That's one example that we have. There's a domestic terrorist attack. Somebody did some horrific things at a synagogue, I believe, and they reached out to DARPA and they wanted to get more information on his online activities. And it's like, wait a minute. I always thought the FBI did that in-house. And for them to go to the Department of Defense seems to suggest that DARPA is collecting a whole lot of information there, and their responsibilities or role is ill-defined. I mean, it's not, they're not just doing work that's relevant to the Department of Defense, right? They're helping domestic law enforcement agencies, and then DARPA goes out and they contact independent, members of academia and people on federal contracts to get data or analysis that they in turn bring back to the FBI and the Department of Justice. So that case, as far as I can tell, domestic terrorist attack, Manos Antonakakis, working at Georgia Tech on federal contracts through the Department of Defense, actually had a hand in that investigation and presumably that prosecution. And I have been FOIAing that all weekend. I think I submitted 11 or 12 FOIAs, and half of them were just generally like, I just want documents from DARPA telling me, like, what is the contractual basis, or what's the memorandum of understanding or relationship. What are the guidelines under which DARPA is going to provide assistance to the FBI for investigations or provide help to the Department of Justice for prosecutions? And that's something I'll pursue, for the next couple of years. I don't care how long it takes. That's a relationship everybody's going to be wondering about. I mean, how many people have been prosecuted due to assistance from the Department of Defense? Hard to know. I see we have a few questions here. Let me see here.
I was just going to do a quick comment.
Yeah.
One of the things that's unusual about DARPA is that it's largely outside of the normal chain of command in the Department of Defense. It's almost what you could consider an independent agency, and it's largely staffed by civilians. So it's kind of a unique portion of the Department of Defense. And, in some ways, I think that could give it a lot of flexibility in what it does and potentially what it could be used for. So the top of its chain of command, it flows almost from the top of the Department of Defense rather than operating down through the whole structure. And then the other quick comment I had was on the Bitcoin crypto tracing. I'm not in IT. I haven't worked in IT for a long time, but I have several friends that are IT professionals. And the thing that convinced them that all of this Russia stuff that Russia hacked the DNC was the Bitcoin crypto transaction tracing that was in there. So they saw that as the definitive evidence that proved that the DNC was hacked by Russia. So for technical people, I think it's a pretty important, strong piece of evidence. And if we learn that it's not real, that's kind of a big deal.
Yeah, it's a good point. Picking up on kind of what I was speaking of before. I mean, it's one thing to have outside experts or technical experts come in and provide analysis, right? If the case is already prepared by the FBI, it's all put together, and then the Department of Justice reach out to technical experts because they want a piece of evidence analyzed. That's standard practice, and a lot of us would expect that to be the norm. But we actually have a case where there are people who are professors at universities that are actually serving the role of investigator, and they're actually finding the evidence that is being translated over to the FBI and the Department of Justice, and it offers up a lot of questions about validation and how does the FBI validate this data or this analysis that's coming in that's going to serve as the case that they're going to bring against individuals, and what qualifies the collection, like how do they handle the evidence out there if they're not trained in any type of techniques. Now maybe we're talking about data, maybe that's a little more cut and dry, but it just really bothers me that they're going to DARPA in the first place, and then DARPA's farming it out to people that they have on contract. I just don't understand that. So I see we have a bunch of questions. We'll get to, I think we can kind of open up to some of those, and then hopefully we get something filed pretty soon. Biden, I am going to add you again. I don't know if there was an issue before, but if you want to go ahead and speak. Looks like there's an issue of some kind. So, Mike, we'll go to you. If you have a question or comment, go ahead. Hey, Mike, how's it going?
Hey, Ryan. I was just, do you think it's possible when referring to attribution that he was referring to the redacted portions of the ICA?
I'm not sure about that. We don't really know what's under the redactions of the ICA, right? The portion that's been released or the unclassified version really doesn't speak too much about the hacks, and it actually doesn't speak all that much about Russian activities other than kind of the Russian news agencies and negative stories they put out about Obama during 2012 election. That's like the one piece that I really remember and stand out without looking at the document again. I just remember it very clearly that the 2016 ICA report about Russian interference efforts referenced Russian news reports that were put out in 2012 against Obama. Like it's just a laughable, ridiculous document, and it doesn't go into any detail whatsoever about anything that's been reported as like the main narratives of 2016. Like there's very, very high level statements saying, oh, we have evidence that Putin approved a plan in order to support Trump or something like that, but there's no evidence. It's just statements with no support, which is sort of a signature of a lot of the disinformation campaigns that we have. And it calls to mind a news conference a few weeks ago where the reporter actually pinned down the press person for Biden administration. And he's like, no, like you're just saying, whatever the case is, like you're not actually providing any evidence. And then the press person was like, no, like the evidence is what we say. It's just ridiculous. And I don't think I have too much more to say on that because there's just nothing to talk about as far as the ICA goes. It's just a ridiculous document. I don't know if anybody else has thoughts on it. Go ahead, but I don't have anything else to say about the ICA.
Well, if it's enhanced attribution that we're talking about, that's a DARPA program that it's theoretically made to identify hackers based on their tendencies and their idiosyncrasies that they probably don't even know about. And again, that's just taking a whole bunch of data and then finding things you could point to. Okay, this was this hacker group, and they, I think they were talking about anything from just the way they like move their mouse, like just things that are very idiosyncratic that could point to a single person or a group of individuals. So that's what Tejas and some of these guys from DARPA were studying with the help of Georgia Tech, and they were trying to expand that. And the DNS was just going to be like another phase of that, I guess. That was my reading of it anyway.
Yeah, and to the question specifically about attribution, I mean, there's nothing we can say conclusively, but it seems to strongly, there seems to be a strong inference to be made that it is talking about the DNC hack. I mean, they reference specifically, fancy bear analysis, and we have chat logs between, I think Tejas is in there, Angelos Karamitis from DARPA at the time, David Dagan, and Manos, and throughout 2016 into 2017, they're talking about Russian activities. They're talking about the hack of the DNC, and it's sort of seems to be a secret chat. It references a report that was delivered specifically to Tejas. I think it was probably October, November timeframe. So I think that's the inference to be made.
Yeah, and that's a good point. And it's funny though that at the end of the day that they applied all these tools to it, and apparently, as far as we know anyway, it was just they went with CrowdStrike and whatever they said, and nobody else seen. Everyone said, okay, CrowdStrike's got it figured out. It's done. FBI doesn't need to see the servers, and I don't think any of this stuff got in the CrowdStrike report, or there was anything pointing to anything but what their technical analysis kind of said, which was real sketchy if you look at it. And then, ultimately they kind of even backed off on the certainty that they had identified who the hackers were. So it's just sort of like, all right, either this stuff doesn't work as well as it's built to, or maybe the answers weren't what they wanted them to, or needed them to be. I don't know. I mean, it's just another interesting little tidbit.
Yeah. Hey, Biden, I added you as speaker again. I don't know if we have technical issues. If you want to try to speak, go ahead. Biden, you there? All right. We'll come back to you. Hey, Wayne, how's it going? Hey, Wayne, how's it going? Back-to-back technical issues. What's up with that?
Hello.
Oh. Hey, how's it going?
Sorry, it's Ryan, right? Sorry about that.
Yeah, no problem.
Yeah, you guys do great work. I've been following you for a few years. I think I started following Bongino back in the day. I don't know if he still talks about it anymore, but he's really good. Just about today, the court proceeding. Sorry if you already summarized it, but if you could just give me like sort of a high level of like how we did in court today, and like what's decided, what's left undecided, and also this judge, is he going to turn out to be an Emmett Sullivan or what?
Yeah, good question. So we have a filing, and we can cover that. The thing to be really excited about is actually what we're still waiting on, and it could be filed any moment. I don't know if Durham's waiting just to let everybody go to sleep or what the case is. He's been filing these cases or making these filings pretty late at night. So Durham's filing a motion to compel documents for an in-camera review, and the implication, and I think the speculation is, he's not gonna hold too much back. I mean, he needs these documents, and there's really no incentive for him to sugarcoat anything or to do like a half measure. I mean, he needs these documents, so he might be a little bit more forthcoming with evidence that he's collected so far. That's why we're all here. I think really tonight is we're just waiting on this filing, and I don't know when it'll come. I assume it should be within another hour, hopefully. But that'll be the major story for this week. That's going to set the tone. Now, there was a filing earlier today, and the judge partially granted and partially denied various motions in limine. I think there's my interpretation is it's a net positive. It's probably a win for John Durham. He got most of what he wanted. John Durham wanted to introduce evidence as it relates to third parties that maintain servers and things of that nature. John Durham's not going to be able to do that, so the judge is not going to allow that aspect. That was pretty far out there. I don't know what Durham was really going to do with that, so that wasn't all that surprising, I don't think. For the most part, I think Durham got everything he wanted. I mean, there's a lot of controversy over this FBI special agent that's going to be testifying. And that, Sussman really wanted to limit it to general DNS terms and defining some different things. And that's exactly what Durham said he's going to do, unless Sussman introduces evidence that speaks to accuracy of the data. There's a little bit of nuance there in the filing and the motion that the judge decided, in that Sussman's going to be able to say that he was relying on what Rodney Joffe had given him. So that's not ideal because that's not going to be enough for Durham to challenge the accuracy of the data. But that's really not central to the case. I mean, the case as it stands is just a false statement charge. And, Sussman lied to the FBI saying he didn't represent clients. That's the whole case. And we have contemporaneous statements that are consistent statements from a couple witnesses, but we also have a text message from the day before where Sussman explicitly says he's not representing anybody. And so there's really no question about whether or not he lied. He did lie. The whole case is going to rest on materiality. And that's sort of what Durham's going to pursue tonight, because having evidence that you can introduce as it relates to Fusion GPS or Alpha and Rodney Joffe in the Clinton campaign being the clients and being the people that came up with this data that Sussman's bringing to the case, that's what makes the lie material. Because if Sussman had told the truth that he got this data from Rodney Joffe, who was working in contact with the Clinton campaign, in contact with Fusion GPS, it would have totally changed the course of the investigation. There's no way that you can go into the FBI and say, hey, I just got this data from this guy that's working with the Clinton campaign, and I just want you to open up an investigation and do whatever, and don't ask me any questions about it. Like, the FBI would say, no, wait a minute. You got this from a guy working from the Clinton campaign? Like, where did he get this from? Or who is this guy? What are his qualifications? Like, what is he doing? And obviously that's what makes the lie material. So Durham's got some. Sorry, go ahead.
Exactly.
Yeah. Hey, Madden Shipwreck is outstanding. Everybody should follow him. He's got a Substack. Everybody should subscribe to his Substack. Ship, I don't know if you have any thoughts you want to share with us tonight, but it'd be great to hear from you.
Just regarding the filing, I would be embarrassed to admit how many times my filings landed ECF between 11:55 and 11:59 p.m. on the day they were due. I'm a bit of a procrastinator, but when they went to all ECF and you didn't have to get stuff to the clerk's office by 5, that extra 7 hours became invaluable. So I'm not sure we're going to see anything before midnight Eastern time.
Well, that's what we were afraid of.
That's why I've thought in the past you need to schedule these things for the day after the filings are due, not the day the filings are due.
I did have that thought earlier. I think I probably will do that going forward. I really thought with everything and with Durham having the weekend that he would give it to us, by 8 or 9 o'clock.
This one's complicated though. This one is going to be This one's going to be long and involved. This depending on what I expect he'll do is he will file an omnibus reply because he filed the motion to compel originally and then they opposed it. So he'll file one document, I expect, that will reply to all the objecting parties and their points. So it could be 40, 50, 60 pages long by the time he's done. Who knows how much? It depends on how much he decides, salt the earth with evidence from the case as he did, in the original motion. So, and that I'm certain that is filling up a lot of the time, is how much do we say that we know?
I'm not sure if you've had a chance to read all those filings that got jammed into the docket last week, but do you see any risk that Durham's not going to get this motion to compel these documents for an in-camera review granted? Or, I mean, is there anything that Durham has to accomplish tonight to make up some ground in order to get that through the finish line?
No, I think, and I haven't read everything, honestly, I haven't, and I have inundated with January 6th filings, some of which I'm coming into cases late and have a lot of ground to make up. Oath keepers, but I think all Durham is asking for here, and the only thing Judge Cooper has to give him, is in-camera review. And then Judge Cooper will actually read the materials that the objecting parties are claiming are covered by privilege and decide, is this covered by privilege or not? That was kind of a point I made. All of the time being spent by a dozen or more lawyers arguing over what is or is not privileged material is all kind of beside the point, because it comes down to what is in the document. Is the content of the document privileged material within the scope of the attorney-client privilege? And there's no way for Judge Cooper to reach that conclusion without reading the documents. That's why it's set up the way it is. You provide, in a very complicated case, sometimes the judge would create a special master and have the special master read the documents and then report back to the judge, but there aren't that many documents involved here. So, Judge Cooper can take 2 hours in his chambers, take a stack of papers and read through them. They're emails, memorandum, whatever they are, and make a judgment based upon the content, whether or not they fall within the scope of attorney-client privilege or attorney work product privilege. Which I think in some ways is a closer call here. I'm completely resolved myself on the question of the degree to which Perkins Coie, Sussman, Elias could rely on a contractor like Fusion GPS to support, possible litigation. I think all their theories are stretched to the max. I don't know that they all hold up under scrutiny, but lawyers hire experts. Is Fusion GPS an expert? Probably not. But that's the kind of claim they're going to make. They're going to try to shove a round peg into a square hole. But there's no substitute for Judge Cooper simply taking the documents and reading them. And then he might put privileged in one pile and non-privileged in another pile, and then give the non-privileged stuff to Durham and say, matter resolved.
It's like only 38 documents, though, we're arguing over on privilege out of like 1,400 or something. But I think it's 38 privileged communications out of 1,400. So there's a small, really small, minority of privileged communications, and you just have to wonder what he's going to do if we over 1,362.
The much more interesting question to me from a trial gamesmanship perspective, and I thought it's a pretty ingenious play by Durham, is this idea of, I'm going to call representatives of the campaign and the DNC to the stand and ask them about documents and force them to invoke the attorney-client privilege in front of the jury. Now, normally, there's and the defense came in, and objected and filed, this litany of cases and case law on how it's improper to have a privilege invoked in front of the jury because invocation of the privilege is not intended to, be a comment on the facts in dispute in any respect. But all the cases they cite are Fifth Amendment privilege cases. And that's ironclad black letter law. You cannot call a witness to the stand for the purpose of invoking the Fifth Amendment privilege in front of the jury, because the right to remain silent is not a commentary on the facts at all. No inference may be drawn under the Constitution. The jury cannot see it out of concern that there's no way to predict how the individual jurors might draw conclusions from it behind closed doors. And no conclusion may be drawn on a fact and controversy from the invocation of privilege, because the witness just simply has a right to not answer. Invoking the attorney-client privilege establishes the existence of attorney-client relationship, which is what Durham is in large measure trying to prove here. That Sussman had an attorney-client relationship with at least two parties that he denied as being his basis for taking the material to the FBI. And so it is invoking the privilege is a way through evidence of establishing a fact in controversy, which is that there was an attorney-client relationship between Sussman and the DNC, and Sussman and Jaffe, and Sussman and Hillary for America, HFA. So that's quite a gambit. That I looked at, I thought that's a maneuver. We'll see what Judge Cooper does with it, because all the case law would seem to run against it, but it's not case law on attorney-client privilege, and it's not cases where the existence of attorney-client privilege was a disputed fact.
That's so interesting. I was thinking about that a little bit earlier. I mean, do you think there's a likelihood that Durham will be able to call somebody from the Clinton campaign or call Rodney Jaffe to the stand and just ask, did you instruct Michael Sussman to take these allegations to the FBI? And then when they invoke, I mean, the basis of it being attorney-client privilege, just as you just laid out, that establishes that there is a client relationship there, and that is material to the case, just as you just pointed out. I mean, do you think that's likely? Or
I don't think it's likely as to Jaffe. Jaffe will assert the Fifth Amendment on the basis that he's exposing himself to Sussman's potentially illegal conduct, and so Jaffe will not invoke attorney-client privilege. He'll invoke Fifth Amendment, so he won't be called. He won't be called for that purpose. The Clinton campaign, you call a representative of the Clinton campaign or representative of Hillary for America or the DNC, and they don't have. First of all, they're both entities, so they don't have a Fifth Amendment right. An artificial entity does not enjoy a right to remain silent in the Fifth Amendment the same way a person does. So they wouldn't have the Fifth Amendment to assert. That's why, Sussman's jumping up and down and yelling and screaming that, they shouldn't be called for the purpose of having them assert before the jury the existence of attorney-client privilege, but citing as support cases that all involve the Fifth Amendment privilege, and then just generically arguing that, it's just a matter of not having a witness assert a privilege in front of a jury. If I had to bet, my bet would be Cooper doesn't allow it. And that's because there's an old saying that a judge never gets reversed for favoring the defendant. It's almost non-existence that the judge gets reversed for not allowing the government to have certain evidence. So it's more likely that he's not going to allow Durham to do this out of fear that he's committing reversible error if he does. So it's also a phrase that, well known to lawyers called protecting the record. Cooper's protecting the record on appeal, eliminating, a ground that Sussman might raise on appeal if he's convicted, that Cooper should not have let Durham do that. So to prevent that appellate issue, Cooper just decides, I'm not going to let him do that. Durham probably doesn't really need it. He's got obviously other evidence to, he's got all of the documentary evidence of, billings and internal memoranda, Perkins Coie, that establishes that he was working on the campaign. He was working for Jaffe. They were clients of the firm. He's got all these other mechanisms, all these other exhibits that he can use to establish that relationship, to call the clients for the purpose of having the client invoke attorney-client privilege to prove the attorney relationship. Cooper might say, not worth the risk. Not worth the risk of having, the appellate court, send back the case and I have to retry it again.
Hey, King, I see you're a speaker now. I don't know if you have any thoughts or comments you want to make.
I'm going to do a sidestep here.
Okay.
I think in looking at this from a trial lawyer's perspective, I see a very intense chess game going on between Durham and the defense team as to materiality. What I mean by that, materiality means, to a layperson, it means that it's really not relevant. It doesn't make any difference. This is Sussman's argument. It doesn't make any difference that I lied about who my client was or having a client. That part of what I said didn't matter. What was important and what did matter was the white papers and the data I brought that I knew and the FBI agreed with me needed to be looked into for various reasons. How would a defense team like Sussman has try to defend this case on materiality? As I see it, they would try to analogize to an anonymous tip. What Sussman did would be no different had he come to the FBI and says, I have a client, but he chooses to remain anonymous, but he wants me to deliver this tip, this evidence that he thinks and I think you might want to look at, but that's not up to us. It's up to you. Here it is. Thanks for your time. That's in the nature of an anonymous tip. And at that point, what they would like to see the evidence be would be that the FBI took it seriously, that they went through their standard investigative techniques, they ran it to ground, they concluded it didn't turn out to be what it appeared to be on the surface, and that's the end of it. It didn't take them long to find that out. So whether he had a client or not didn't really matter. You get the same result. That's going to be they hope their case will look like. Durham, on the other hand, has this problem. He's facing a DC jury pool that's going to be, 90% or more Democrat. Many of those, probably the majority, are going to come into the courtroom believing that there was evidence of something nefarious going on between Donald Trump and Russia. And some may even believe that the FBI dropped the ball by not finding it. So Sussman wants to get those jurors on his side to say, yeah, certainly they need to look at it. It doesn't matter who brought it. Could be an anonymous person, could be Hillary Clinton, could be anybody. They need to see it. That's the case that Sussman wants to try. Durham understands that. And Durham would like to show, and he's set it out in his indictment and his various filings since then, that there was a nefarious scheme afoot, that this was a political game being played by Clinton, that behind the scenes, they didn't care whether the evidence was real or not. Their object was to get something in front of the FBI to launch an investigation so they can immediately bring it to the press and use the fact of the investigation to amplify this so-called evidence of Trump-Russia collusion so they can dirty up Trump and win the election. That was their game. And Durham's indictment and much of what he's written since then kind of they draw that picture. So the decision by the judge this morning kind of goes to the heart of that chess game. The judge said that he would not allow Durham to put on evidence to introduce evidence through his expert or through any other means that there was something wrong facially with the data. It was either spoofed or fabricated, made up in some way. Mr. Durham, you can't put that evidence on because that's going to taint the jury and unduly prejudice Mr. Sussman unless you can tie that kind of evidence to some knowledge that Sussman has. If you can't show that he knew that his people were fabricating something or presenting something they knew was sketchy, you can't use it. That plays into Sussman's defense. So that now the ball's in Durham's court. And one way he could maybe bust through that is through these privileged documents. Is there anything there that is now in the judge's hands to be looked at in camera from one of his two main witnesses, Mr. Dagan or Miss Seago? He would like one or both of them to be able to present evidence that, yeah, everybody knew this was sketchy. It was papered over in the white papers, and Mr. Sussman was involved in that process because he knew, as we did, that what we were doing was a trying to pull the wool over the FBI's eyes to get this investigation started. If that's ideally what Durham would like to prove, and the privilege is being thrown up as a defense to keep him out of those kinds of conversations if they happen. That's my view.
It's a lot of good stuff there. I'm not sure I can add to anything you just said. You just put it so well.
As an aside, I just was scrolling through Twitter. Jack Dorsey came on and fully endorsed and said he supported Musk's effort to take the company private, that he thinks the company being public has been the downfall of the company. Says the guy who took the company public.
That's interesting. Yeah, I think I just glanced at that. He said something about it should be regulated as more of a public utility, I think he said, rather than a operated as a company, which is pretty interesting.
Yeah.
Sure, Elon's not real thrilled about that if we just dropped $40 billion.
I see we have a bunch of questions, so let me get a few more people in here. Paint Person, how's it going? Paint Person, how's it going?
Can you hear me now? Hello.
Yes, how's it going?
I'm good, thank you. I have a question, and it kind of relates to what the gentleman that just spoke at length so wonderfully. It relates to that, and it's this. James Baker's phone records, which all of a sudden appeared, okay? And do you think that bit of the information that Durham has probably gleaned from that phone, the messages between Baker, Say, and Sussman, is giving him ammunition with these most recent filings? Well, what he's going to ask for to show to the jury. And I'm a layperson, I don't know anything. And my question too is will the phone records be available to the court, to the jury, or do we have to go through this whole process with the phone records from James Baker to get them in front of a jury? That's my question.
I'm not sure what phone records there would be.
All of a sudden he found the text. He found remember he had lost his cell phone?
Yeah. That's all we know that there is. And the reason we know that is because Durham reported that Baker, within the last month or two, figured out he probably ought to search what's in the cloud.
Right.
So he pulled text messages from the cloud. And
can you honestly believe that Baker didn't know to pull it from the cloud? Come on. That seems like someone had to tell him. I don't know. I think he was obfuscating for a while, and finally he said, well, I got to pony up and show my phone. So I'm sorry to have interrupted you, but
no, fine.
Yeah.
If you're my vintage, the cloud would probably be one of the last things you would think of. I can't speak for Mr. Baker.
Oh, okay.
But a lot of us lawyers, and Baker's a lawyer, we predate technology of most kinds that are in use today. So I can't criticize any lawyer with gray hair like Baker has to not know where and how to search for everything. I would put that more on Durham's team for not asking and making sure he did.
Correct.
But one thing we can say is we don't know if that's the only text, and we won't know until the trial. So it's just pure guesswork as to whether there's anything else there.
Okay, here's my second question, and this is the last question, and I'll hang up. Why is it that Sussman his lawyers wanted so much to give immunity to Jaffe? What is the strategy behind that? That's my last question.
One, they think if immunized, they say Jaffe could be a witness for Sussman and solve that issue that I described. That is the major chess game going on, whether or not there's any evidence that Sussman should have suspected that there was something wrong with the data, or that his client was up to no good by packaging it and presenting it as he did. They implied that Jaffe answers that question and will stand behind the data and basically absolve Sussman of any bad purpose. There may have been a secondary hope, that is, that if Jaffe were given immunity, Jaffe, probably would be the number one target of Durham on some future fraud or conspiracy charges, or one of the major targets. And if he were immunized, the chances of dragging Sussman down with him would be lessened. That'd be my educated guess on it.
Yeah, on if I could weigh in just briefly on the question of Baker's phone, I would note that as it turned out, I think this turned out to be Baker's personal phone, not his FBI phone, and it's possible that he didn't realize that he had a message from Sussman on his personal phone. Didn't even recall it. Maybe a lot of government officials try to be relatively, and more so I think years ago than recently. But they try to be very try to separate which phone they use for which purposes, and don't have business calls on their personal phone, and don't have personal calls on their business phone. FBI agents, Baker wasn't an agent, but FBI agents, carry two phones. Some of them carry three phones, believe it or not. And they have a phone that can receive classified information, and a phone that can receive unclassified information, and a personal phone.
But weren't they friends, Baker and Sussman?
I don't know how close they really were. Remember, Sussman's been out of the department for a long time. Sussman left the Department of Justice like in 2012. Now they both worked in the same. Well, actually, Sussman was in a litigating section. He was in cyber, and Baker was mostly in technology policy, not a litigating section. And those are kind of those groups do different things. Baker was more involved in dealing with Congress and the Patriot Act and that kind of stuff. And Sussman was actually out doing cyber crime type cases.
Just a 2 cents on Baker, if I can. I'm a contrarian on this one, but I think an ex-Brookings Institute, ex-lawfare guy who currently happens to be the deputy general counsel at Twitter, interesting resume for Baker. I think we need to keep the eye out for him, because it's just too convenient that he remembered this text message existed just after it was outside of the statute of limitations to be useful for anything other than exculpatory for Sussman. So I think you give him way too much credit. I'll just mark myself there, and I'll listen now.
Well, I think that the text message was actually the day before the meeting with between Sussman and Baker. So the statute of limitations was actually the day before the indictment actually occurred. So it wasn't the case that he immediately, outside the statute of limitations, remembered this text message. And I think it's also worth noting that for whatever reason, John Durham didn't subpoena Baker. So Baker was cooperating of his own volition, and just kind of happens to stumble across this text message.
Yeah, I'll say this in Baker's defense. That guy spent 24 years in the Department of Justice as a career official, starting as an honors program hire in, the early 90s, maybe late 80s. He was one of those guys, kind of like me. He went through multiple administrations. He rose through the seniority. And I don't think he was ever a political appointee. I think he was always a career DOJ employee.
Well, I just read his deposition, and the way he was like, yeah, I saw it and I got it out of my office as quickly as I could. It's almost like I knew there was something not quite right about it, and I wanted out of, I didn't want to look at it anymore, so I gave it to the other department, criminal. I think that's where he said he had sent it. So I just thought that he was evasive in his deposition. Maybe he's friends with Durham, or they have a history or whatever. And, I know Durham. That's another thing with Durham, too, is that I just don't know why they only had one charge against Sussman. I know I'm jumping all over the place, but I kind of just got into this. Why are they undercharging Sussman? Why is it just lying to the FBI? I don't understand that.
Well, I think he was developing a case, and as we start going through these FOIA documents, it seems to be the case that this really developed in the middle of 2020, that Durham started to get into Rodney Joffe, and he started getting into Angelos Karamitis and these researchers at Georgia Tech. And I don't think it was really until maybe February 2021 that Durham really started to pick up the pace, and you can kind of see it in the FOIA releases where it seems to accelerate at that point. And then by July 2021, that's when he gets Manos and Tanakakis. I guess I'm not actually sure that he went before the grand jury, but he did get a grand jury subpoena in July 2021. We also have grand jury subpoena for Georgia Tech to compel some documents there. And then David Dagan testified before the grand jury and also got immunity in July.
Right.
And then I know by August he was getting a little bit more information from Karamitis. So he was still very much developing a case, and then due to statute of limitations, he had to charge Sussman with this crime. And then I don't know if one of the lawyers wants to speak to this, but it might be the case that he's using this lesser charge as sort of a carrot and stick situation where he's trying to induce some cooperation from Sussman with potential of a conspiracy charge being out there for him. Ship or King, I don't know if you have any thoughts.
No, I've said exactly that's exactly what I think he's doing. Whether Sussman will go for it or not, you just don't know. Maybe it's cooperation that develops post conviction if he gets a conviction. I think Sussman, I've said before, Sussman is sort of a fulcrum. Sussman links the actors on the Alpha Bank effort to the campaign through Elias. Through how much did the campaign, senior campaign officials like Jake Sullivan or Janet or Jennifer Palmieri or who am I leaving out?
Robbie Mook.
Robbie Mook or Hillary Clinton. How much did they actually know, and how much direction were they giving through Elias that sent Sussman off on this effort? Or did Sussman bring it to Elias, and Elias brought the campaign in on it, and everybody decided, yeah, that's a good second front. If you said Steele and Fusion GPS were the first front, then Alpha Bank becomes an effective second front with Fusion GPS pushing that out to the media as well. And so Sussman is that fulcrum. You could say Elias is too, but I think Elias is a target. He's not going to give Elias an opportunity to cooperate or a cheap way out, but he's given it to Sussman.
It seems like Elias and Sullivan, from what I can tell, are the ones who really were kind of the nexus of this. I mean, Sullivan on the campaign side and Elias running the smear campaign. But that's as far as I can tell. Do you think so?
Well, so I think Sullivan, because of the history, which you kind of have to study to understand it, I think Sullivan is the one that's tight with Hillary Clinton because he was a chief aide to her when she was Secretary of State. And so, if somebody's ever going to draw her in, it would be him.
Yeah, and I actually think Sullivan is actually Rodney Joffe's main contact on the campaign side. So I think that's pretty interesting as well.
Now he's the national security advisor in the middle of a potential war. So
yeah.
Well, you could say the same thing about Gary Gensler. I mean, I pound the table on this one all the time. I mean, Gary Gensler was the CFO of the Clinton campaign, and he was, proving the checks that are going out to Perkins Coie and, basic accounting. He was getting these Perkins Coie invoices and whatever's on them. I don't care if Perkins Coie has it down as a confidential project. As an accountant, as a CFO, you don't just get to approve that invoice. So you have to have a clear understanding of what that project is. And it's actually one of the more common practices in the accounting world where you get a legal invoice and you push back on it. I mean, that's almost standard practice. You go through that line by line just to make sure, a lawyer's not billing you at $750 an hour and booking in, lunch breaks and things of that nature. So, Gary Gensler's now the head of the SEC. So it's just incredible that they were able to continue their careers in advance, and for whatever reason, Gensler in particular has escaped scrutiny. So
and add to that the layer of billing that is advanced costs for like expert services. Perkins Coie is paying Fusion GPS, but Perkins Coie is getting that money back from the campaign. So the campaign is actually paying Fusion GPS, and does the campaign know, or did it ask what Perkins Coie was getting for the money that the campaign was paying Fusion GPS?
It's a good point. I think there's a lot of ground for Durham to cover on just on the accounting side. I mean, you look at Gensler, and he was like a staffer for Senator Sarbanes, I believe. Like Sarbanes-Oxley, like the ubiquitous term, is from Senator Sarbanes, and Gary Gensler was a staffer. Like, he knows accounting. He wrote the regulations. So there's really no claim of ignorance that he can even make. He knows the basic accounting standards. He knows, as CFO, approving the payments, you have to have a clear understanding of what these accounting records are for. So it's a boring case. Like that's not attractive for everybody to talk about. Like, oh, he doesn't, debits and credits, and he doesn't, he was just paying these invoices with confidential project or whatever the case is. But that seems to be one of the more stronger aspects of the case, in my opinion.
That's another interesting point. We were just looking at today. It wasn't the contract with Fusion, but it was a different Perkins Coie contract. And just the boilerplate seemed to be, if you're going to hire a subcontractor, and if you're going to spend any of our money, it needs to be signed off on by Mark Elias or whoever he designates. So the odds are they had a similar contract in place, and any money they spent, if they hired Fusion, and if Fusion then hired Steel, if they were spending money, it was signed off on. I think that's definitely going to end up being true.
Well, I think there's like a certain amount of plausible deniability that they want to maintain. I mean, I think Hillary Clinton is surrounded by people who know how to protect her. And, Jake Sullivan knows what to tell her and what not to tell her is the way that I would assume that these things go. But at some point, assurances have to be made, and they have to be clear about what they're doing. So,
hey, just a heads up, Margot is tweeting the latest filing. She's threading it before it hits court listener.
Is it out?
Yeah, it's out. She's got it on Pacer.
Oh, that's exciting.
And I see some flame symbols on her first paragraph.
I'm sure it's going to be good. Let me pull up Margot.
Can't wait till all these people are in jail. I can turn these alerts off and get my phone back.
I see Molly in here. I don't see Margot.
I asked Margot to come, but I think she said she was going to be busy, and then she's crushing it with tweeting this out. So figures. There we go. Intro is fire, she says. So just going to start scanning this. I'll try to read whatever I can, and then obviously we'll get a lot of reaction here tonight.
So we're gonna need to vamp, folks.
Yeah.
Everybody that's trying to read is reading. We're gonna have to fill in some space here.
Let's see. Okay, opening paragraph. Durham says, as set forth in further detail below, none of the arguments or facts contained in these parties' filings or accompanying affidavits undermine the government's limited request that the court review 38 relevant documents in camera to determine if they are properly withheld. So there you go, right off the bat, Durham saying all these findings are garbage, and Judge, you should review these 38 documents in camera. Let's see, paragraph 2. Just kind of.
Isn't that what I said?
That's exactly right.
Yeah, I put on Twitter a lot of times. A lot of this stuff's not really that complicated.
Let's see here. He says the defense, in this case Sussman, they're advancing a seemingly broad theory of attorney-client privilege, namely that Fusion GPS's political opposition research, which triggered a sizable outflow of unverified derogatory information into the media, the government, and the public, was in reality confidential expert work intended to support legal advice regarding libel and defamation. Even more novel, the purported privilege holders here contend that they all maintained a common legal interest in that work, despite the fact that the group includes Tech Executive 1, which is Rodney Joffe, with whom none of the other purported privilege holders had any formal or informal legal relationship. Well, there you go. Apparently, there is no financial or contractual basis to actually claim that there is a legal relationship. That's interesting.
Another way of saying that is we all hang together or we hang separately.
Let's see here. How many pages is this? Anybody been able to pull it up yet?
Yes, 20 pages.
20 pages?
Mm-hmm. And it's got an attachment, Exhibit A, which is filed under seal. Exhibit A would be the evidence Durham is attaching to prove that Fusion is an opposition research firm. That he references the filing references email after email after email to various newspapers and journalists of things they need to print, and I'm still going through it.
Yeah, absolutely. I'll just try to scan through this. I'll hit the major bullet points. Sorry for any delays for the listeners. We'll circle back through this certainly. So bullet point number 1, Durham says government's motion is timely. So that's responding specifically to points raised by Sussman that the motion to compel was untimely. Durham says no.
So this is saying that they contacted Fusion this is saying that they contacted Franklin 4 in May of 2016, which is well before Lawrenson and Joffe supposedly got in touch with them. And that's
I believe there was a June 2016 article from 4 that we were looking at. So that could come into play right there. Let's see here. Just reading at the top of page 4, and I'll let everybody else kind of do the deep dive into this. But let's see. It says it was only recently when the government determined that it would need to call an employee of Fusion GPS as a trial witness that the government concluded these issues could not be resolved without the court's attention. Because all or nearly all of the Fusion witnesses' expected testimony on these matters concerned work carried out under an arrangement that the privilege holders now contend was established for the purpose of providing legal advice, it is essential to resolve the parties' potential disputes. Okay, so that wasn't quite as interesting as I was hoping it would be. Let's see here. I'm going to go ahead and go to JH. See if I can slip in a little more reading here.
Now, FOIA, we've already surmised that Durham knows what those 4 pertinent emails say, because we're sort of confident that Seago has been talking, so he's just trying to get him introduced into evidence.
That's a good point. That is potentially true. I think what you're referencing, I believe it's 4 emails from Rodney Joffe to Fusion GPS that the Clinton campaign was claiming privilege over. And as you stated, he might very well have a good idea what's in there, because Laura Seago has been granted immunity and seems to be party to many of the conversations. So that could very well be the case.
Okay, the filing is up in the Nest. If you follow the link now, anybody can read along.
Good stuff.
I had a quick question. So if the judge rules that this is not privileged and it's admissible, does that exhibit become public potentially?
My understanding is that Durham can make it public if he chooses to, once it's not privileged.
I doubt that he will, because unless the court tells him to. You're talking about potentially his evidence at trial. It'll be made public then.
Durham writes that the government is filing Exhibit A under seal due to personally identifiable information contained within the referenced emails. The government will file a redacted version of Exhibit A on the public docket if the court so orders. So right there, that seems to reference data that was collected by Rodney Joffe, perhaps, and then they're alluding to it. So it seems to be perhaps emails, I'm guessing from Rodney Joffe to Fusion GPS personnel, containing some of the database information that he had tapped.
So, question for Dr. Shipp. Being that we think that Seago has talked, she's singing, and Durham knows what those emails say, would he have not inferred or just flat out told the court, hey, we have a witness saying this, and we want to show you in these emails? Is there a reason not to do that?
No, I mean, you're trying to persuade the court to look at the emails. And if you think you know the substance of the emails because a witness who's seen them has given that to you, then you confront that out to the judge and say, because the judge might look at the email and realize you're wrong. Your witness has not described it accurately.
I got you. Now, would there be a reason he's slow playing it and not doing that intentionally?
You mean not? Well, I think he's just reluctant to put out trial evidence on the public record in this fashion.
Okay.
Nothing prevents lawyers from, making a filing with all their exhibits, except, I mean, there's a scheduling order which says you must file all of your exhibits by a particular date in advance of trial. I mean, you could do that 6 months early if you wanted to, but all you're doing is sort of giving up, giving the other side more time to, effectively try to craft a strategy to deal with the exhibits.
Okay. I see. And that could be a reason why he kind of slow played the Seago. Well, they probably know that the defense knows that Seago's been talking, most likely.
Yeah, this filing definitely. Sorry, it just definitely says that Seago is.
Yeah,
sorry, go ahead.
Yeah, I think that Durham has said he has already produced jinx statements of all the government witnesses.
Mm-hmm.
Presumably, she's a witness, and whatever her 302 statements are, or if Durham's not using the FBI, it wouldn't be a 302; it'd be some other agency's form. And if she testified for the grand jury, I think all of that's been produced. I think I read that he said he's already produced all the grand jury testimony as well.
Mm-hmm.
So the defense has got all of it already, which then, when you're trying to kind of read the tea leaves, the fact that the defense has all of the evidence or all the testimony these witnesses are going to give and is fighting this hard to keep this attorney-client privilege claim in place to prevent Durham from getting his hands on this evidence,
Roger.
That ups the stakes a little bit as to what is in these documents that Durham wants to actually use the documents themselves.
I understand. That makes sense.
At page 18, Durham gives us a pretty big hint. He says that I think 3 of the emails are emails to and from Jaffe and Fusion GPS that Jaffe is asserting privilege on. At page 18, Durham states that the only person associated with Fusion that Jaffe ever communicated in writing with was Laura Seago, who now has immunity and will be a government witness in this case. So what we just speculated that Ms. Seago knows what's there and what Jaffe's said about it. She's clearly told to Durham, and he knows there's some gold to be mined in that communication.
Well, there's some pretty incredible stuff here, and obviously I've not read even close to all of it. But starting on page 8, Durham starts getting into dates and specific communications. I guess it's really page 7 of this, but there's some pretty damning stuff. I mean, they got a lot of stuff about Sergei Milyan in here. They're also talking about Trump Advisor 1, that seems to be Carter Page. They've got a New York Times reporter. They've got a ABC news reporter emailing one of the Fusion GPS co-founders concerning Sergei Milyan, stating in part, making arrangements to interview Sergei Milyan. We should chat. So that's really interesting that a ABC news reporter is emailing that to Fusion GPS. One would have to guess at how ABC News knew that would be significant to that Fusion GPS person.
That's going to be Brian Ross.
It's got to be Brian Ross. That's what I was thinking. On the next day, Fusion GPS employee emailed the same ABC News reporter, seems to be Brian Ross, copying the Fusion GPS co-founder, and attached a comprehensive report regarding Sergei Milyan. The report appears to contain information gathered from public sources and or commercial databases. Weird. So they seem to have this set up in July, and they seem to have a clear direction of what they're going to do with Sergei.
That was the same week that Danchenko was desperately trying to arrange a meeting in New York with Sergei, and he failed.
That's a good point. And then we get a little bit more about Sergei on page 9. So he says on September 27th, a New York Times reporter who would later publish an article regarding Alpha Bank's allegations emailed one of the aforementioned co-founders of Fusion GPS asking if Sergei Milyan had an email address associated with Alpha Bank. On the same day, Fusion GPS co-founder replied to the reporter stating in part, see below from iptracker.org from 3 weeks ago. Kind of reading through that. So the email then includes additional screenshots, links, and other internet-related information pertaining to Sergei Milyan that Fusion GPS had apparently gathered. I'd be interested to know if that was actually compiled by Fusion GPS or if they got that from Rodney Jaffe.
I like the next paragraph. On October 5th, 2016, one of the aforementioned Fusion GPS co-founders sent a Yahoo News reporter, Michael Iskoff, isn't he at Yahoo at this point?
Yes, absolutely.
A September 1st, 2016 draft of the same Fusion GPS white paper that the defendant had provided to the FBI General Counsel 3 weeks earlier. Not only are they sending Iskov the Steele dossier, they're sending him the Alpha Bank stuff too. That's new to me. Maybe everybody else knew that, but I didn't know that.
And the import of all this is, as he argues later in the brief, is that the nature of privilege is that it's confidential, and the nature of attorney work product is that it's confidential and kept confidential, and there's no attempt here by Fusion to keep any of this secret. They're telling everybody they know in the press what's going on.
Well, that's a great point, and it ties in really well with what Ship just pointed out. I mean, what they gave to the FBI, they sent directly that same copy to the news media. So that seems to destroy their privilege, right? I mean, they sent exactly what they gave the government to the media. So now one would have to believe, I mean, everything related to that white paper has to be subject to the government's motion. Just kind of reading through more of this here.
This may be sort of a dumb procedural question, but when we classify a witness as a witness for the defense or a witness for the prosecution, is there like a phase that goes by where they're more or less, picking teams or something, or is there something that prevents a witness from being a witness for both the defense and the prosecution? In other words, how do they decide who's the witness for who?
All right, that's it. Let me address that. That's an interesting point, and I just went through this in a trial where I represented a witness 2 weeks ago. The government presents its case in chief first, and it calls witnesses. Those are government witnesses. They were called by the government as part of the government's case in chief. And cross-examination is typically limited in broad respect to the subjects that the witness just testified about. So you're always dealing during the government's case in chief on direct examination and cross-examination. You're dealing with the government's version of facts that the government is putting forth to the jury. The defense can call one or more of the same witnesses back again, this time as defense witnesses, and talk about completely different subjects because they're part of the defense case. They're part of issues that the government didn't even care about, didn't address, or maybe didn't know about because the defense kept it under wraps. The defense doesn't have the same responsibility, the same obligation to produce witness statements to the government that the government has to produce, the obligation the government has to produce such statements to the defense. So in my case, I had an ex-wife of the defendant. The defendant, she was the first witness called by the government because they were also business partners before the divorce. Then the defense brought her back as the very last witness in the case, as a defense witness, to talk about a whole bunch of subjects that the government didn't know about because we hadn't volunteered it. She wasn't asked, and they were not subjects that were part of the government's case. So, yes, witnesses can appear at different points in the trial for different purposes based upon what the party that calls the witness is trying to accomplish.
Let me add the one person we've been talking about as being a government witness in this case, Laura Seago, was an employee of Fusion GPS who asserted the Fifth Amendment. Durham, in his last round of pleadings last week, announced that he would be getting her immunity so she could testify without fear of prosecution. And that's why we call her a government witness.
Sega's an interesting case because if you look at all these conversations and emails where they're talking about who's in a meeting, her name's always left out. It was Rodney Jaffe and Sussman and Elias, and her name's not showing up in meetings that we're pretty positive she was in. It's just really ironic that apparently she was the invisible woman, and well, guess what? That's what's going to come up and bite these guys in the butt, it looks like.
I've kind of noticed that Karamitis has sort of disappeared in the same way.
Karamitis is going to be a little bit. I mean, he's not that close to what Sussman is being charged for. He's a little bit further out there in that, he was working at DARPA at the time, and I think he'll come back into the fold a little bit later, and I think in future cases. But I don't think Durham wants to reveal too many cards around Karamitis right now. I see a couple of interesting sections here. So I'm on page 13 right now. Durham notes that Podesta and Mook, he's talking about their affidavits that they filed with the court last week. And he says the Mook and Podesta affidavits provide and describe no examples of occasions when Elias advised them on laws concerning libel, defamation, or other legal issues. In addition, the government has interviewed Mr. Mook. During that interview, Mook stated that he could not recall any specific instances of legal advice that Perkins Coie provided on the basis of Fusion GPS's work. When asked if he would have remembered such advice if it had been given, Mook stated that such a question was difficult to answer given the passage of time. So that's pretty good. I mean, Durham pins down Mook on any specific examples of legal advice given as the result of what Fusion GPS did, and he had nothing. So that seems to blow up a portion of what they had stated last week, and that Fusion GPS was assisting Perkins Coie with by providing legal advice in anticipation of litigation.
I've got a question for King and Ship as prosecutors and people that have been in the culture. Is there a movement or just are judges going to be real unhappy with using these kinds of protections when they shouldn't be, to the point where maybe this just judge or not, but is it just like a sore spot where it's like, no, we know what you're doing. You're using attorney-client privilege to protect unprotected speech just to keep yourself out of political trouble or other legal trouble. You think, is that like something that is really a sore spot?
Well, I will say something that's probably not appreciated well enough is that a judge like Judge Cooper or any federal judge in pretty much any federal courthouse, they have so many cases over the course of 5 years, 10 years, 25 years of career. Nothing bothers them too much anymore. They've seen so many things in criminal cases from both sides that nothing is too shocking at any point any longer. So they don't have, I don't think, visceral reactions to these kinds of things. They just work through the issue and come to a decision and move on. Because if they didn't do that, the work would simply be overwhelming. They just don't. I mean, think about, Judge Cooper's got January 6th cases he's got to deal with, with all kinds of, novel, factual and legal issues. And the filings come in. I couldn't even imagine, the fire hose that filings come in to a federal judge's chambers. I mean, I think there's a misconception that federal judges aren't busy. Federal judges are extraordinarily busy, and their staffs are not really that big. They have like 3 law clerks, and what you can't lose track of is, he's got this case. It's not terribly complicated. And he's also got a couple hundred civil cases, many of which are extraordinarily complicated, especially in D.C. So, no, they don't lose any sleep over this stuff. They don't waste any time over this kind of stuff. they get through the issues. A lot of issues in federal criminal cases are repetitive. They arise in case after case after case after case. They know, they know from institutionalized memory the case law and the issues and how to resolve many of these kinds of problems that tend to recur. So a novel application of privilege, oh well. Big deal. Move on.
There's some really good stuff in here. So page 16, he gets into Rodney Joffe. So Rodney Joffe was claiming basically his communications were privileged because it's like work product of a retained expert. But Perkins Coie hired Fusion GPS to assist the Hillary Clinton campaign on the DNC. They did not hire Rodney Joffe, and they say Tech Executive 1 did not pay for Fusion GPS's services, and Perkins Coie did not charge Tech Executive 1 for such services. So basically, Rodney Joffe is trying to claim, or people are trying to claim privilege around Rodney Joffe, and Joffe paid for nothing, and Joffe was not paid for anything. So, in the absence of any financial relationship there, I mean, they can't really claim he's an expert providing any type of services that would invoke like a work privilege or a attorney-client privilege. I mean, they've got nothing to stand on there, it would seem.
There's a beautiful line in here that says, the party's privilege theory here is akin to claiming that a homeowner pursued legal advice regarding noise complaints by having his lawyer hire a marching band to perform in his backyard.
Just stepping back and looking at the forest of the trees. The trees are all these thousands of filings going back and forth just to protect some emails over a 1001 charge. And I mean, you attorneys can agree. Durham is looking for gold, or looking to expose gold in those emails. This is a lot of stuff for a 1001.
Yeah, I mean, whatever's behind these redactions and whatever's being withheld for 6 years, it's going to be damning. I mean, it's going to blow up the entirety of anything that they're claiming, and I think it's going to allow Durham to pursue criminal conspiracy charges against everybody that's named in this filing. And I see. Sorry, go ahead.
Well, it could also just be the precedential effect of getting that veil pierced once and for all for future cases as well. So it may not be a bombshell email that points fingers, but what it does is it gives us that next case where we don't have to argue this again.
Yeah, and I think I would pose that question to Ship or King. I mean, once this in-camera review happens, and if the judge looks at these 38 emails and says, this is ridiculous, I mean, there's absolutely nothing here that's privileged. If Durham wants to pursue the rest of the body of emails and everything else that's subject to privilege claims, he should have a much easier time doing that, right? I mean, that seems obvious, but is it going to be this big drawn-out fight, or is it going to be pretty much, hand him right over?
If Durham takes the same tack, which is, Judge, we need you to read each and every email and decide on its face whether it's privileged, it's going to be a long, drawn-out process because, as Ship said, that these judges and their staff are busy, and that's asking a lot when you're talking about over 1,000 emails. He may just, at some point, cut to the chase and argue that we have here evidence that these communications, while on the surface are attorney-client, are really performed in the execution and implementation of a fraudulent or criminal scheme, and therefore there's no privilege because of the crime fraud exception to attorney-client privilege.
Yeah.
That's the short circuit way to get all of it.
Yeah, I think it's a two-step. I think King's exactly right. There's a two-step here. The first step is, Your Honor, look, review these emails, and you will see for yourself that there's no attorney-client confidentiality intended in the content, as reflected by the content. But more importantly, from that fact, the court should conclude there's no attorney-client relationship here, and therefore all documents that the government seeks are not subject to privilege, and we shouldn't have to have this privilege fight in the future.
It's my understanding that in a particular case for the prosecution, there's some point in time where they're not allowed to introduce new evidence. Assuming the judge says that all these documents are not privileged and Durham has access to them, what evidence that he gleans from these can be used in this actual case against Sussman?
Well, he can use everything he gets unless the defense claims that they're being produced too late in time and are therefore prejudicial. But as I think Durham points out, we've been providing, the government has been providing privilege logs all along. So the defense has known that there were privilege fights going on here, and Durham is in effect producing them as soon as he is able to. Now, then the remedy to the defendant is, okay, the government's not at fault. Durham's not at fault for the delay here. The delay was caused by the refusal of the parties asserting privilege to produce the documents, which now they've done. And the defendant's remedy, if the defendant feels like he's been prejudiced by the delay in production, the remedy is to continue the trial date and give the defendant more time to prepare.
Ship, what about the argument that these are being produced pursuant to a grand jury subpoena, and the time for the grand jury taking any evidence that can be used in this case is ended with the indictment?
Oh, no, that's not true. That's not good law. The grand jury can continue to consider evidence of other criminal conduct. So
I'm talking about of this particular criminal conduct for use 3 weeks from now in this trial.
Well, okay, that's a very good point that a lot of people don't understand. I'm glad you brought that up, is that the government cannot continue to acquire trial evidence through the grand jury after an indictment is returned. But that may be why Durham only sought a single count, because he can say, oh, no, we have other counts under consideration, and that's what the grand jury is receiving evidence on, is other counts. We haven't determined yet whether there's sufficient evidence to seek an indictment on those other counts, and that's why the grand jury's work is continuing.
So if this evidence was subpoenaed before the indictment, that doesn't really have any bearing. What's more important is what had been produced by the time of indictment as to what can be used in this trial.
No, if the evidence is lawfully obtained and lawfully disclosed, even if it's disclosed late, the remedy for the defendant is, okay, you need more time to prepare. How much more time do you want?
It looks like Durham's filed a motion with the court asking permission to go ahead and file that redacted version of the Exhibit A. So that'll be interesting if we get that tonight or tomorrow.
You won't get it tonight.
Yeah. Just probably in bed.
I got to drop here in a second, but are you seeing that they were sharing Sergei Milyan's IP addresses? Fusion GPS was?
Yes, that seems to be the case. Of course, this is like a first look, partially distracted, but yeah, it seems Fusion GPS is sharing that information with various reporters, and they did take allegations to the FBI. I believe Steele gave it to Bruce Orr, gave him allegations that Sergei Milyan was using this alpha server in some form, and alluding to allegations that he was serving as a conduit between Trump and Putin.
So one interesting thing is that when you send an email to someone, you can include images, and what we sometimes do is use what's called a tracking pixel. And basically, if your email client loads images automatically, then you can grab their IP address from that tracking pixel. You can do something like this to confirm that they opened the email. But I'd be very curious to know if Sergei looked back at that Danchenko email and found a tracking pixel in there. It's a pretty common thing to do. That would be awesome if we found that out. But I got to drop right now. So thanks for hosting this. I'll probably try and drop in later.
Yeah, thanks for coming on, Sean. I appreciate it. That was a good
That's
point
really
too.
interesting. We can ask him. I think one of us asked him to go back and look through his emails to find the Danchenko email to begin with, right? So I'm sure he still has it. I'm sure that's something we could check out.
If that was in there, that would be sick. All right. Thanks, guys.
All right. Thanks, Sean.
I want to go back to something Ship said, which I agree with, that most judges, too busy to get exercised about this. There are, in my experience, there are some exceptions. Judges take the legal profession, seriously. They do not look kindly on lawyers who let themselves get used by clients who are committing crimes or frauds. To stand in front of all that, to hide it, and particularly in a mob case, there will always be a mob lawyer who may have engaged in some shady practices professionally that either gets the lawyer into the soup with his clients, or at least has done sufficient work to hide what the clients have going to get the attention of a judge. And this could be one of those cases. What happened here should not happen ethically by any responsible professional.
Yeah, I think I agree, but I think I was answering a different question, and I'm not suggesting that you're misconstruing what I said. I don't think the novel application of privilege here by Latham and Watkins, or actually it's not Latham and Watkins, it's the attorneys for the parties asserting privilege. That, the novel application of privilege in that respect, I don't think that's something that's necessarily going to irritate a judge. I agree 100% with the view, however, that the activities of Sussman and Elias in helping to orchestrate and perpetrate what clearly appears to be a political dirty tricks campaign, and then hiding behind their position as lawyers to shield themselves from scrutiny, that is the kind of thing that a judge will not like. Like, you want to be a political dirty trickster, be a political dirty trickster, but don't hide behind the veil of legitimate and important attorney-client privilege to do so.
I know it's not RICO, and it's never RICO, but isn't this case inching ever closer to RICO?
Well, I have always been of the view that it's that RICO is more harm than or more trouble than it's worth. But RICO provides Durham some advantages, and 1512 is a RICO predicate. That's corruptly influencing a official proceeding. A charge that's gotten so much coverage in the January 6 cases, with the meeting with Congress being alleged to be an official proceeding. A federal grand jury investigation is clearly an official proceeding. So, did Sussman and the other actors intend to spark the FBI into going to DOJ and getting a federal grand jury proceeding initiated? behind this information, you're going down the road if you're using false information, knowingly false information, that gets past the corruptly element. And then, corruptly influencing, are you trying to steer a grand jury investigation in a particular direction or into being? Well, that's 1512, and 1512 is a RICO predicate, and it's not too big a leap from there to say you could, not to say you should or that he will, you could call the Clinton campaign, a racketeer, influence, corrupt organization, which is what RICO stands for. Because, that would be a racketeering act. You have to have two of them, though. That would be a racketeering act, and, done by Now, the reason why I suddenly kind of seized on this a little bit was because of the statute of limitations advantages that a RICO conspiracy charge holds. I put this on Twitter yesterday, just sort of out of the blue. RICO conspiracy charge doesn't require an overt act. And typically the statute of limitations in most conspiracy cases begins to run upon the commission of the last overt act. That's when the 5-year statute begins. The last thing the conspirators do. So what do you do with a conspiracy that doesn't require an overt act? And there are, a few federal conspiracy statutes that don't require an overt act. Well, what the Supreme Court has said is that conspiracy continues to run for purposes of the statute of limitations until its purpose is accomplished or it is abandoned. And that becomes a matter of drafting. How does the prosecutor define the purposes of the conspiracy? Because defining the purposes of the conspiracy gives you the idea of when it might be accomplished or otherwise abandoned. So that's just something to chew on.
In analyzing or assessing whether a RICO charge should be brought, I look at it this way: RICO, compared to conspiracy, a conspiracy case, as Ship just described, compared to a RICO case, the RICO case adds an extra layer of proof for the civil plaintiff or the federal prosecutor. That extra layer of proof has to do with the enterprise. You have to prove that the enterprise was engaged in interstate commerce, and you have to prove that the persons charged associated with or were employed by the enterprise for the purpose of conducting its affairs through a pattern of racketeering activity, that is, managing the business or the enterprise in such a way that it committed all these crimes, and they formed a pattern. It's truly at least one, maybe more additional elements that you have to prove, which complicates the prosecutor's life a lot, where you could accomplish pretty much the same thing with a simple conspiracy charge. The place where RICO really lends itself to a separate charge is the situation where you have different crimes all being conducted out of the same operation, the same business or enterprise. For example, if Durham had evidence that Dan Jones's company that he formed, the Democracy Integrity Project, went out and raised money through fraud and then used those funds to pay people to seed the investigation, the grand jury investigation, with false evidence. Just this is totally hypothetical. I have no evidence he did this, but that's the kind of operation that they would think seriously about RICO. Simple presenting false statements to the FBI by a group of people, that can be done just as easily and probably more efficiently as a conspiracy charge.
You know, I'm reading through this filing. I'm getting to page 18. So on page 18, Durham begins to talk about the standard under which he's seeking these documents. So what he first says is that the government has a substantial need for materials. And second, he says that the government cannot, without undue hardship, obtain the substantial equivalent of these materials by other means. So I'm not too worried about the second part of that, but the first part of that, a substantial need. So this case is just a simple false statement charge. Sussman lied to the FBI saying he did not represent a client. So there's obviously some materiality. Materiality is going to be a focus of the case, but as it relates to these communications that are the subject of these privilege claims, is Durham at risk at all with us trying to demonstrate a substantial need that the judge needs to look at these documents? I'd love to hear your thoughts, Ship or King.
I think I think that's actually a much lower bar than it sounds like. It's not that bar does not. That bar cannot be characterized as we might lose if we don't get this. That's not what you have to show to establish a substantial need. You just have to show basically that it's material and relevant on an element of the offense such that the government can make use of it if it has it. It essentially is. I don't think the standard means any more than it's not cumulative or tangentially relevant. You know, if the defense could show that what is in here is cumulative of other evidence, or it's only of tangential relevance to the core of the offense charged, then you wouldn't have a substantial need. But substantial need is not, we'll lose if we don't get this.
It's actually broader than that. Substantial need in the terms of, in the context of the attorney work product, is kind of a amorphous standard that is driven by, one, the importance of the evidence to the issues at trial, and two, the ability of the person seeking the evidence, in this case Durham, of getting it in some other way. Can he prove the same thing some other way without breaking the attorney work product protection? If the answer to that is yes, then you don't get it. But if he can show that these particular pieces of work product can only is the only way he has to prove something, the court will give it to him.
Perfect. Thank you, guys. I don't know if anybody else has a question or comment that's already a speaker. If you do, go ahead. Otherwise, I'll take a few questions while everybody kind of absorbs this. I imagine we might still get a few more new guests here. I'm not sure if Fool Nelson's probably out there somewhere. He might pop his head in. So let's see here.
Only 20 minutes to Better Call Saul.
Better Call Saul?
Oh, well, that's probably not on the East Coast. I'm just now getting to it. So.
Hey, Bernard, I'm not sure if I'm pronouncing that correctly, but if you have a question or comment, go ahead. Bernard, are you there? Bernard? No? Close. I tried. Jay, let's go to you. Question or comment, go ahead. Hey, Jay, are you there? Oh, boy. Striking out tonight.
Hey, this Exhibit A, I was just catching up on that part. This Exhibit A is going to be bombshell. It gets released unredacted.
I'm sorry, you cut out a little bit there. Could you repeat that, please?
Yeah, the Exhibit A with all of the hundreds of emails between Fusion GPS and their stenographers in the media, that's going to be a bombshell if that gets redacted, released.
Yeah, I see that Technofog is all of a sudden talking about some emails, and he's got some screenshots that he's discussing.
Okay,
yeah,
take a look
it's
at that.
It's in the filing tonight. That's what the Exhibit A is really going to have. That'll be
okay,
fun.
let me jump in on that. If what he has filed under Exhibit A are hundreds of emails from Fusion to members of the media, that's salting. That's salting that was the reason for the entire exercise.
Yep.
It gave him an excuse to do that.
That's exactly what Technofog is talking about. He's talking about hamburger emails.
Oh man, that's gonna be huge.
And well, now didn't he say that he would redact, that he would not have personal identifier information, that he would redact personal identifier information if he filed it?
And that's
he
that's
did.
That's exactly what is still redacted.
I get. Well, it sounds like he's got not all the names are redacted. Maybe just their email addresses are redacted.
Yeah, you got phone numbers on here from Techno.
Yeah.
Oh boy.
Emails and phones.
Okay, so Technofog has some emails up here. Pulling this up here. So this is Glenn Simpson to Tom Hamburger of the Washington Post on July 29th, 2016. And let's go first to this. So first email in this chain is from Tom Hamburger to Glenn Simpson, July 29th, 2016. Subject is, for your information, we are getting kickback to the idea that Page met Sechin or Ivanov. Quote, it's bullshit, impossible, said one of our Moscow sources. So that's pretty incredible. So they're feeding information to the Washington Post, and the Washington Post is saying no, like there's no way. Glenn Simpson replies just a simple okay. And then Tom replies to Glenn Simpson. He says, for your information, passed on by another reporter who likely doesn't like this story. Just letting you know.
A lot of people involved in that joint venture, huh?
Yeah, well, yeah, it's going to get interesting here. And then Glenn Simpson replies to Tom again, no worries, I don't expect lots of people to believe it. It is indeed hard to believe. So this is going to be huge. Not sure how much Techno has. Maybe I'll try to DM him here. Looks like he's got a thread started. Let me go to the next one.
He's got a bunch of it up on his Substack.
Okay.
How does this guy work so fast? How did he get
guys, I'm looking at it on Pacer right now, and there's no redactions. I think this was somebody made a mistake.
Or you know what? Either somebody made a mistake, or Judge Cooper simply said, "There's no reason to redact any of that stuff. Put it up."
They got the emails redacted, and the phone numbers are wide open, so that's good.
No, there's a mistake here.
Somebody screenshot it.
Yeah, download this stuff.
I'm grabbing a copy of Pacer.
Okay, so next one here is Franklin 4 to Jake Berkowitz of Fusion GPS. He's CCing Peter Frisch. Subject is R.E. Carter Page. This is May 14th, 2016. And Franklin 4 says, I'm going to do some work on Rick Burt. I bet he does some work for Russians. He was on the radio posing as Donald Trump advisor today. Jake Berkowitz replies, Burt is on the board of this Russia-Turkey fund. That's kind of interesting. And then Franklin Foer replies to Jake Berkowitz and Peter Frisch. He's also on the board of Alpha Bank. This is incredible. This is members of the media assisting in a political scheme.
May 14th.
Yeah, and May 16th. Yeah. This is huge. We got Franklin Foer. You know, he is not a reporter. He is working actively with Fusion GPS. This is pretty incredible.
Now let me posit a question.
Yeah.
For the
blown away here. Go ahead.
How many employees of the United States District Court for the District of Columbia do you suppose are working at midnight on a Monday night? to take this down.
0.0.
There's some phone calls going out right now.
Well, we'll find out if there are or not. Well, you know what? There's a 24-hour available magistrate and a 24-hour available district judge.
Well,
they rotate that.
Techno's got what, 360,000 followers. I mean, this is everywhere now.
No, I know that. But if this was, or is this Durham giving the middle finger to Merrick Garland and James and
Goodlander?
No, the deputy. I started to say Jimmy Gorelick. That's how old I am.
Why am I drawing a blank on her name? Lisa Monaco?
Yeah, Lisa Monaco.
Yeah.
Maybe he's getting throttled a little bit.
Well, this is going to provide some cover. I'm trying to pull up Techno's Substack. There you go, everybody. You should subscribe to Techno's Substack.
One of the best.
Let's see here.
This guy is unbelievable. He's been unbelievable. I mean, I've had some. I've never talked to him directly. I've exchanged. We got emails. We go back and forth on email, but what he pulls off is just unbelievable. He's so technically sophisticated in how he gets this stuff immediately.
On a Substack, he's also talking about DARPA contracts and classified data. That's going to be interesting.
Where are you? What page?
I'm on Techno's Substack right now, so I'm just reading through what he threw up. He's got a much longer posting.
Do you have a date?
No, Techno put it as like a subheader. Fusion GPS alleges Sergei Milyan is clearly KGB. Sorry, guys, I'm just reading through some of this. Peter Frisch emailing Franklin Foer, CCing Jake Berkowitz. This is June 28th, 2016. Your editor should say it's great. Jake and I will read more closely and make some suggestions. So Franklin Foer said, I'm out of town this week. I handed in a draft of the piece. Here's a copy. This is June 28th. Said it's not all edited. Forgive the rawness. So he's sending a draft to Fusion GPS. That's incredible. Peter Frisch, before that, had emailed, this dude is key. He's talking about Sergei Milyan on June 27th. Wow. Fusion GPS telling a Wall Street Journal reporter to call Adam Schiff or Dianne Feinstein about Carter Page. Call Adam Schiff. Peter Frisch of Fusion GPS is telling somebody to call Adam Schiff to check allegations that he's putting out into the media. Well, that's interesting. Wow. I little upset with that one. Why is he saying Adam Schiff? All right, so let's talk about DARPA and confidential. So Techno writes.
Well, he's writing about stuff that you got in your FOIA request. He says in the last paragraph.
Oh,
You've already read
okay.
this. You've already read this.
Okay, well, in this case, I do know that part. That's interesting. Yeah, Techno's swinging for the fences. This is good. All right, sorry. I don't know if anybody else has questions or comments. I'm just absolutely blown away right now by that. So somebody pick up.
I'm going to jump off. You probably need to reschedule another one of these in a couple of days, but I want to try to read all this stuff and process it.
Yeah, it's going to take a couple days to process. I
Is
really
that
appreciate
Exhibit
coming
A
on.
really out?
This is finally proof of what we've always known was there, and that the media was complicit in this entire thing. This entire thing could not have happened without the media playing its part.
Yeah, well, I mean,
venture.
These emails show they weren't journalists. These were political operatives, and Durham's got to look at these guys as part of the conspiracy. I mean, they're part of building these narratives in these cases explicitly. I mean, they're part of the research on this. So Durham's got to look at them as conspirators. I mean, he's got to at least consider it.
Yeah, there's a point where, freedom of the press no longer applies, and the traditional, journalists' exceptions, to providing whatever is it's out the window. So when they're complicit in crimes or potentially crimes, our traditional view of what the press's role is in reporting information is gone.
Now what's going on here is probably First Amendment protected. It's opposition research helped and encouraged by the press. The part that makes it a crime is to pass false evidence on to the FBI to start with. I don't see anything about that here yet, but who knows what's in the alleged privilege documents.
Yeah, I would kind of say if the press knows that it's working as an echo chamber to amplify information, I would think that would kind of tread the line pretty closely.
Well, I think that's a political scandal, but I don't know that it's a criminal offense. But it certainly is, it is something that, Congress can and should look into.
I mean, if Durham can obtain information that explicitly shows that these guys knew some of this information was false before they wrote stories, can he pursue criminal charges? I mean, can he?
No.
If they knew the information was false.
No.
No, that's not a crime.
First Amendment, yeah. They might get sued for defamation, but as far as criminal,
well, I'll tell you what. I already fired off a quick DM to Leslie McAdoo Gordon, who represents Carter Page in his case against the government. Said, grab this filing before it goes away.
Is that available somewhere now?
It's not clear. It is not on Court Listener. I'm not sure where Technofog got these emails, to be honest. He does reference there's hundreds of emails, so I don't think
they're on Pacer.
Okay.
Can you grab them?
I'm not. No. No, I can't. But
I can grab them. Let me do that.
Somebody's going to pay the 10 cents to put them on Court Listener.
Yeah.
Yeah. I will do that.
Now, the couple of those email excerpts are showing where the reporters were actually facilitating information exchange and helping refine the story. So that could, really genuinely ensnare them in this whole overall conspiracy and joint venture thing for a couple of them. They're not just megaphone stenographers. They're active participants in the conspiracy.
Yeah, but you got to. But that leads to what conspiracy are we talking about? What is the conspiratorial agreement? And the conspiratorial agreement has to be to commit a crime. And political dirty tricks are not necessarily a crime.
Sorry, guys. I'm just downloading these documents from Pacer. I want to have a copy myself.
What if a journalist knows that they are acting a part to corruptly influence the FBI?
Can I interrupt in case someone doesn't want to waste money, more money on Pacer? I uploaded the 62 pages to GoFile. You'll see it on my Twitter account.
All right. FOIA fan, I see you're requesting to speak. Mansour, I'll add you too. FOIA fan, how's it going?
This is very entertaining. I haven't downloaded the stuff from Pacer yet, but I did recognize the one you were reading from Technofog about Schiff and his colleague in the Senate, because the body of that email was in the text of Durham's filing. He just redacted the names, like Senator 1 and Congressman 1. So it's funny that the unredacted version of that is apparently on Pacer. But I will just say this. The context here legally, that the excuse for filing all of this was to challenge the assertion of privilege. And it was always painfully obvious to me, and I think to Ship and to other attorneys, that this stuff not only wasn't privileged, it wasn't close to privileged, it wasn't arguably privileged. To even entertain an idea of privilege, to put it on privilege log, in my mind, is something that I would never do. I think I would be afraid of being sanctioned for it or disciplined for it ethically. It's not close. It's not arguable. This idea that, maybe we'll be sued for slander by Trump because he's very litigious, and therefore, we hire smear merchants and op researchers, and that becomes privileged? Well, suppose I want to rob a bank. Suppose I want to murder somebody. Suppose I want to paint a house. Anybody could end up suing me at any time. So what? That's not lawyering. It's got nothing to do with privilege, and it's not preparing for imminent litigation under the work products standards. It's a joke. It's not privileged. And when Durham gets a ruling that this body of 38 emails aren't privileged, if he wants to, he could go back to a grand jury, serve another subpoena, get all this stuff, and he'll have a ruling from a court that applies to Hillary for America, that applies to the DNC, that says this whole body of work isn't privileged. And then he can get the stuff. I wish somebody had done this 5 years ago. I wish somebody from Congress had done it 5 years ago, because it was obvious then, and they just sat there quivering, doing nothing, taking a bunch of depositions and lying down every time privilege was asserted. But hey, we're here. It's a good day. I can't wait to read these emails.
This is incredible stuff. I got a little upset there when I saw that about Adam Schiff. I mean, Fusion GPS telling anybody wants to verify their information to go talk to Adam Schiff is just incredible. I mean,
Hey,
Republicans go ahead.
Yeah, I need to sign off here, but I want to, if I can just take a moment. As most listening here probably know, I am representing several January 6th defendants. I've got a handful that I think, have legitimate claims to innocence. All of my work is being supported by crowdfunding. None of them can afford to pay for the cost of their legal defense. I'm doing it at a substantial, with a capital S, discount. And we've set up a third-party fundraising. This is not connected to John Pierce. That's a whole different story that I won't even bore anybody with here. But I'm going to start putting this out on Twitter a little bit. It also has a Facebook page, and to the extent that anybody is sympathetic or interested in taking a look at some of my guys, I've got military veterans, I've got law enforcement people, I've got 5 sitting in jail for reasons that are just leave me scratching my head. I could use the help. So, but I will continue to participate in these little sessions. I find them entertaining and invigorating and fascinating, and I think there's a lot more ahead for us. So with that, thanks everybody, and I'll check back with you all again next time.
Thank you, Shep. I really appreciate when you come on and share your time. It's always great to hear from you.
Yeah, Cody's link's up in the nest for anybody that wants to see this stuff. So I would highly recommend you download it immediately and check it out. It's wild.
Full Nelson, I see you joined us. I don't know if you have any thoughts that you want to share. If you do or don't, go ahead.
Oh yeah, sure. Obviously, I like the filing. It's interesting. Well, I mean, I guess those pages just dropped, so I kind of want to go read those. And I kind of want to get the chronology down. I don't know, like, I haven't been able to absorb and put everything together yet, but I'm still like searching for stuff that's like related to that, what Brennan got like in that late July and stuff like that, where Barr basically, I mean, like my hypothesis has always been that basically the Russians intercepted like report 95 being passed around like on July 26th to 28th or something. And it's interesting that they're talking about, I mean, we already knew that Simpson was coordinating with ABC about Sergey at that point. So there's an email that he's passing a report about Sergey. So I'm looking at that stuff. I might go and look at the emails actually to see if there's anything else about that. But obviously, I think they make really good arguments about that none of this stuff is privileged, really. Seago's the witness. Which I think she's the one that they're trying to give immunity to, right? At some point.
Yeah, that's right.
I had another thought, but then I forgot about what it was. Yeah, I just need to reabsorb it a little bit more and maybe look at some of these emails. Yeah, that's it. I'd like to see more about this story about Sergey connecting to Alpha Bank, basically. I would hope one day we'll get that with Steele's report 139, which is all about Sergey and Alpha Bank, but that hasn't popped up anywhere. I'm hoping at some point we get that, but still no. But seems like the judge is going to have to review this stuff in camera, I would hope. I didn't get to hear any of Ship's legal analysis, but I'm sure it was spot on.
Yeah, thanks. I was just tweeting out those documents. I just saved a copy and uploaded it to our own hosting platform too. So, yeah, if anybody wants to check those out, I'm just blown away. Just kind of starting to read through these here again.
Did you see
Yeah,
what?
Don't take us spaces when all this stuff is dropping, man, because I just want to go and like read this stuff.
Yeah, I mean, go ahead. I don't mean to keep you, but
Oh no, I'm going to be listening, but also reading a little bit. I don't really have too much data right now until I can get the details down.
Yeah, no problem.
I quickly read the 20 pages while I was on the bike at the gym. So.
Yeah, and here's the email. This is, let me see. This is page 37 out of 62. This is the one where Peter Frisch is.
Brian Roth or Mosk or.
Yeah, I want to look at that too. This email is from Peter Frisch to Michael Isikoff on October 5th, 2016. He is sending him Alpha Bank research documents of some kind. I mean, this is crazy. So, looking for that ABC email here. If anybody else has anything to say, go ahead. I'm just riffing here. Mark Hosenball of Reuters, this is July 25th, 2016, to Glenn Simpson. Subject is millionaire, which is a play on Sergey Million's last name. And he says, please remember to send me stuff on Sergey the Millionaire. Also, if you have stuff on the Carter Page guy, including his most recent Russian excursions, please send. Doing 2 Russian hacking stories today and might be able to do another as early as tomorrow. Below is the link to first of 2 today's stories, RE hacking. Okay, that does not look good.
Just point out that Glenn Simpson and Frisch are CC'd or party to most of these emails that I'm looking at, and that can't be good for them. They're not journalists, they're smear merchants, and they've already, seemingly have some exposure in this whole thing. This cannot help their case.
Yeah, I mean, here's emails to the Wall Street Journal. This is Jay Solomon. And Jay is saying, hey, gents, your thesis of Trump being a Manchurian candidate is worse than originally presented. Do you guys have anything more on Trump's ties to Mammadov? I know an Azari guy who is pretty read in on this, but I wanted to know if you had more. This is Matthew Mosk of ABC. So this is July 27th, 2016. This is page 14 of 62. Let me get to the first email in this. Glenn Simpson to Matthew Mosk, July 26th. Says, subject, nice story. Give me a ring if you can. Matthew Mosk replies, just got in. Another story pops tomorrow with Good Morning America. Want to grab breakfast around 9. Glenn Simpson says, depends on when I get to bed tonight. Matthew Mosk, another email, says, make an arrangement to interview Million on camera. We should chat. I mean, they're setting up Sergey Million. ABC is a witting partner in this scheme. That's the reason they're giving Fusion GPS a heads up. They know that there is a scheme that is being created around Sergey Million. That's the only reason to send that email.
The stuff later in the document from Hosenball at Thomson Reuters is great. He talks about, it's right after they get the Trump statement about the email server being for marketing purposes. He sends Fritsch the question, how do I get behind it? These guys, I tell you.
Hey, you guys see that Fusion was emailing, I think it's between Fritsch and Seago. We're emailing each other in May of 2016 about Carter Page and Alpha Bank. And I had no idea that those 2 entities were being connected so far back. And it kind of pushes back, at least for me, it makes me question what people knew and when they knew it. And I'm glad it went back to at least May. It's right before Christopher Steele got hired.
So here's one flagged by Larry Beach. I'm just retweeting this now. This is as it relates to. This is actually from the filing tonight from John Durham, but it's quoting emails from Fusion GPS co-founders to Isikoff on October 31, 2016. The same date that Slate and the New York Times published articles on the Alpha Bank allegations, and he's quoting from emails that I'm sure are in the mix of all this. And he says, one of the Fusion GPS co-founders says, big story on Trump Alpha server moving early evening. Off the record. U.S. government absolutely investigating. Campaign will light up, I imagine.
Got a general question about this filing. Whenever Durham files these things, is it his responsibility to redact or the clerk of court?
I assume they submitted this all to the court, and that the court made a massive mistake here, because what Durham filed was, he said, I'm submitting Exhibit A under seal, but with leave of court, there is a redacted version of Exhibit A.
That's not what happened.
That's not what happened.
No, somebody at Durham's office screwed up and filed it this way.
I'm just,
really?
I was not hoping for that.
I mean, I'll ask King. King, you brought it up on Pacer. Is that correct? It's sitting up there on Pacer.
It's on Pacer.
Yeah, yes, it's on Pacer.
That's where I got my copy from.
What's the judge doing in this case? Is he going to be pissed off at Durham for doing this?
Well, Durham will have some secretary or paralegal who did it by accident, but it is his job to make sure it doesn't happen. It was a screw up. He's going to get spanked for it probably, but these things happen.
Yeah.
But it's got nothing to do with the court. The court clerk, it's not the court clerk's fault.
Yeah, I just want to make sure it doesn't have any bearing on admission of evidence.
So there's like a button. Obviously, I've never been on Pacer before, but when he's submitting these files, he's supposed to click something that seals the document. Is that generally correct, or?
Yeah, I mean it's automated. When you file something on Pacer, you're doing all the work.
Mm-hmm.
If you have a question and it's during normal hours, you can call a clerk and ask some questions before you do it. But once you hit file, it's there.
Yeah, it's filed actually directly in the clerk's docket. The clerk keeps an electronic docket of every case.
Oh wow! So there's no filter
in that, and then Pacer, as a third party, picks it up as it gets filed.
Gotcha.
And the way you file something is you electronically create a cover page, and then PDF what it is that you're wanting to be filed, and attach it, and then file it. Your copy that you actually file in the record should have all the redactions.
Yeah. Going back to one of the particular emails that Durham mentions on page 7, bottom of 7, top of 8 in his 20-page filing about the meeting with Page and Session. You know, they called it bullshit or whatnot. I found the article that CNN wrote up on it. And when you read these things with a critical eye, like lefties can't do, you can see there's no actual proof. It's allegations. I don't know how I can post a screen cap or picture to this Spaces. I'll post it on my page, but you can see the wording of it, how it's just so ambiguously misleading how they do this crap.
My mind's blown right now. I'm going to go ahead and take a few questions and see if we can try to absorb some of this a little bit, because even knowing that, it's one thing to know something's true, right? I mean, we knew they were collaborating with journalists, but when you actually see it, it's worse. That's true with so many different things. I mean, actually seeing it's always worse. Susie, I just added you as speaker. I don't know if you have a question or comment. Go ahead.
I just have a question. At what point, where is the line that these reporters cross where it's you're doing your job, whether you know you're lying or not, versus you're part of the criminal conspiracy? Do they have to take money for it? What is the line that they have to cross?
That's a good question. I mean, to hear King and Ship a few minutes ago indicated, I mean, this is all covered under First Amendment protections, freedom of speech, the right as journalists. And I mean, I would really hope that there's some novel understanding of a conspiracy that Durham might attempt here, and that these reporters may, and this is subject to further investigation, they may have known this data was false when they wrote the story. And I would like to see an attempt made at pursuing a conspiracy charge under the idea that these were efforts to advance goals of a conspiracy as witting partners. And obviously that's subject to having that evidence that they knew that the information was false. But I'm just I mean, they're obviously involved in the research efforts. I mean, they're contributing to Fusion GPS's body of work here. I don't know, King, or anybody else, if you have any follow-up thoughts on that, but
yeah,
I don't think we've ever seen this before as a country before, right? I mean, we've never seen it this explicit and this egregious.
But don't forget one thing, though. We do know that Fusion GPS actually paid, I think it was 4 reporters to run stories. We don't know who those 4 reporters are, and the MSM doesn't seem to care. But I agree with what Ship and King said earlier, which is it's not against the law to tell a lie. It's not against the law to tell a lie in the newspaper, and it's not against the law to tell a lie even if you're paid to tell a lie. So I don't see that these people are going to be pulled into a conspiracy as defendants. On the other hand, they'd make wonderful witnesses, wouldn't they?
I will definitely defer to you guys. You're a lot smarter than me, and obviously you have the expertise and the knowledge in this field. I will leave it at that point. Let me grab a few more speakers here.
Hey, FOIA, just to play devil's advocate here. You know, it looks like some of those guys that Simpson was working with, they were in on it. But if you look at the last email to Reuters, he was just giving him a heads up. He wasn't really working with him, but he was giving him a heads up, you know, saying it's being investigated using the laundering process that we've always talked about. But some of the guys were in on it. Some of them were just being pushed nudges.
Sorry guys, just a little bit distracted as I read through everything and try to absorb it all. I will add John as speaker. John, if you have a question or comment, go ahead. John, are you there? Let's go to Aaron. How's it going, Aaron? Aaron, are you there?
Oh, sorry, mic was off. You got me now?
No problem. Yeah, there you go.
Do you think it's possible? Last time I talked to you guys, I asked if Garland was going to shut this down, and y'all said no way. Do you think it's possible that Durham leaked this, intentionally filed this as a way to keep it from being shut down? And number 2, real quick, is did y'all hear Elon Musk bought Twitter? And I'll take my answer off the air.
Yeah, I mean, I don't know that any of us can speak to the intention of John Durham behind this, but it's certainly true that it will have the effect of solidifying it and firming up any questions around that, right? I mean, there's just no way that he could be shut down at this point. I mean, he's got 3 indictments. He's had some really strong filings already, but now you're talking about public anger. I mean, people are going to wake up tomorrow, and people will be reading these emails showing, some pretty. I mean, these are some pretty damning emails. I mean, this looks really, really bad, and with that amount of public anger, I mean, there's just no way they're just not going to be able to shut down John Durham, especially with the midterm elections 6 months out. And then your second question was, or comment was about Elon Musk. Yeah, that's gonna be awesome, right? I mean,
you heard that, right?
Yeah, I mean,
okay, I just didn't know. I didn't know. I thought you guys were too busy digging.
Yeah, that was the first thing I was following this morning was Elon Musk. So that's good. I've had 3 accounts banned on Twitter, and none of them were for good reasons. I think I lost 2 of them for yeah, like I lost it for posting FOIA documents. Like that's messed up. So I think I'm safer for that now. So that's good.
It's gonna be crazy. It's gonna be lit. I'll let you guys take it off from there.
Yeah, I appreciate it.
You know, Durham is known for being straight laced and not leaking. That's his whole reputation is no leaks come out of this office. He walks the line, and that's the reason that he's the perfect guy. He's slow. We're all upset. You know, we're all, hey man, you know, get this stuff out. We're waiting. But the upside of that is his reputation is it's sterling. So all right, who knows why this happened? Assuming it was a mistake, but the upside of having to deal with all this delay and all the things that we're not real happy about is that he has the reputation to say this. I did not do this on purpose, and you should believe him. I don't think the left will. They're going to play it up no matter what. But realistically, he's not the kind of guy that would leak something like this. He's never has in his career. There has been no leaks out of his office. So the fact that he would choose this moment to do it, it could be true, but I think it's real easy to say no, that's not what happened.
Just be clear, this is not a leak. This is something he's filed with the court. He tried to do it under seal, and then he wants to file it publicly, but redacted. And he's somewhere between the first and second and maybe third filing. It's all public.
Well, the other thing in his official filing, he referenced having hundreds of emails, but this is only 62 of them, folks. It's going to be a fun ride.
Yeah, I mean, if Durham gets his motion to compel and there's thousands of other documents from Fusion GPS, they're not necessarily to reporters, but there's going to be a lot more damning evidence, and they've been holding on to it for 6 years for a reason, and they know it's going to be might be prison time for them. So I'll try to take a couple more questions here. I am going to start wrapping this up here in another 15-20 minutes, I think. Hopefully, maybe, possibly. Don't know that I can go to sleep, but we'll take that as we get there. So JH, I'm going to add you back. I don't know if you have a question or comment. Go ahead, though.
Have any reason to think it was accidental? Is there a reason why this filing should have been redacted?
Yeah, there's some telephone numbers and other personal information in there.
Let's see. I will add Chuck as speaker. And I'd offer this up. I mean, we have a few hundred people here tonight, and everybody's obviously interested in Russiagate. I mean, if you have friends out there that haven't been following this might be the time to send them some stuff, right? Send them some articles from Margot Cleveland, send them some articles from Technofog, and introduce them like, hey, this is what we've been talking about for the last 5 or 6 years, because we are on the cusp now. And, I don't want to promise timelines of when stuff's going to happen, but I think it's pretty clear there are stuff, there's more that's going to happen here. So I just want to throw that out there for no particular reason. Let's see here. Chuck, how's it going?
Going good. How are you?
Oh, pretty good.
Pretty exciting.
Better now.
Yeah. I'm not sure how this relates, but maybe someone can shed some light on this. If I recall, news articles were used in FISA applications at some point in time, and I could be wrong on that, but I'm pretty sure I recall correctly. And if so, if the author of that news article or the publisher knowingly conspired to publish information they knew was false that was going to be used in a FISA application, would that potentially make them liable as well? So I'll listen off speaker. Thanks.
They could be charged as part of the conspiracy, but if they are a news publisher, protected by the First Amendment. Any prosecutor trying to nail them would have a high hill to climb to show that they actually did know and intend that what they were publishing would end up in court in a FISA filing. That's so bizarre and unusual. You'd have to have almost written proof that happened.
Well, just remember this back and forth of operatives to the media and the media to operatives. There are some aspects of that is normal, par for the course. Who's sourcing who's pushing their narrative, trying to cut the wheat, from the chaff. These reporters are hearing a lot of different stories from every operative inside the Beltway and out. So the emails themselves aren't necessarily indicative of some horrible, terrible thing. It's the sausage being made that happens that most people don't think about it. How do they write articles without background material, right? But the back and forth, I think, is what's going to be damning and going to be a pox on all their reputations, because clearly they're participating in the development of that story. And I hear what everybody's saying about the legal liability isn't going to be there, but the ethical, moral culpability absolutely will be, especially when they're voicing doubts about it, but presenting to the public it as if it were true.
I could see this leading to like some landmark rulings on what's protected by the First Amendment and what's not. This is sort of also so unprecedented that I don't quite know how to process this.
I think that's right. I mean, I defer to King and FOIA Fan and everybody else for their legal takes, and they're 100% right. I have no question about that. But somebody's going to try, right? I mean, there's going to be some challenges on this. There's just no way. All these protections for all these different reporters that are actively working in the schemes. Somebody's going to have to take a look at that.
We give a tremendous amount of power to journalism, and to journalists, and the expected result is that they're not going to abuse that power. But I mean, if anything's ever been an abuse of that power, it's this. It's just, I don't know. It just seems way out there.
Well, yeah, and nobody wants to be censored, and nobody wants to live in a world where the government, is in charge of, who's right and what the right narrative is, and we all know that. We're always on the short end of the stick when it comes to that. But this really isn't sustainable. I mean, is this going to be on CNN tomorrow? I don't know. I doubt it. Is it going to be on MSNBC? I doubt it. It certainly should be. I mean, they should be giving their viewers a heads up. Like, nobody should be blindsided when the conspiracy charges actually drop. And I don't think there's any question that there will be conspiracy charges dropped at some point here. Let's see here. Oh. Sorry, guys. Just trying to... Hey, Robin. How's it going? Hey, Robin.
Hi, can you hear me?
Yeah, how's it going?
It's going good, thanks. You guys are doing such great work, and wow, what tonight is mind-blowing. I do have a question about it's kind of an off the thing about the thing I saw on Margot's page today about a letter going to Durham regarding FEC filing that Hillary had to pay a fine for basically giving the wrong information to the FEC filings for, her Oppo research stuff. And now also it's kind of like she's playing both sides and saying, well, my information was this to go into the filings. And then she's claiming legal protection in Durham's filing, or in Durham in the case against Sussman and stuff. So I'm wondering, will that have anything to do with the court as far as will they? Well, I don't know if it went to the court. It went to Durham, right? So I don't know. Is that anything to even consider? Maybe that's my question.
I can answer that. It might have been something to consider, but Durham did not raise it, so the court will not consider it.
Okay.
Durham could have presented the court with maybe the record in the FEC case in which charges were brought, civil charges were brought by the FEC based on their conclusion there was probable cause that the campaign lied in its filing when it categorized the payments to Perkins Coie as being for legal services, when in fact most of them were passed on by Perkins Coie to Fusion for opposition research. So, in essence, the FEC charged the campaign with lying in their filings. The campaign chose not to contest it, but agreed to a fine and signed an agreement as part of the settlement that they would not contest the finding of probable cause. Durham could have used that, but he decided not to.
Okay, good. Thank you. I mean, not good, but I feel like whatever they can get her for, I really want that to happen.
I'm sorry, I just cut out there. Could you repeat that, please?
You mean what I said?
Yes, I'm sorry. My audio cut out.
Okay, I was just saying the last thing I said after King was saying about, he was explaining about Hillary's FEC filing and how it wasn't going to be used because Durham's not going to, because Durham didn't put it in his filing. I said whatever. I'm just concerned. I want everything to be used against Hillary that can be used. I'm sorry. I know I sound very awful and biased, but I just think she's gotten away with so much over so many years, and I'm just so done with it. That's all.
Yeah, I mean, I think everyone on this chat, I mean, we just want one system of justice and we want it to be equal. I mean, we don't want to live in a world where we feel like conservatives are always charged and prosecuted to the fullest extent of the law, and then liberals are not. And to see them go after President Trump with just absolutely everything. I mean, the Trump Organization stuff and just digging through whatever, and then that case falls apart and there's no accountability. I mean, there's no walking back of all the stories when the prosecutors resign because they don't want to bring the case because there's nothing there. And they do that with everybody that's connected to Trump. And then, I've seen a lot of stories on CNN about that when it turns out there's really no substance to it. And then all these developments are just not even covered on CNN at all. I mean, not even with a partisan slant. They just don't cover it. So, I think everybody agrees with those sentiments. Let me see here. Jeff, how's it going?
Hey, how's it going? A couple of things.
Pretty good.
I think the whole idea of secular reporting, that's kind of been what like the folks like the Bonginos of the world have been kind of onto, since a few years ago already, right?
Yep.
It's just, everyone kind of knew that it was going on. There was just no official proof via an unredacted court document, right? That just drops, at midnight on a Monday. Whether it's inadvertently unredacted or whatnot, we shall find out tomorrow. But that, and I think maybe an entrepreneuring one of our entrepreneuring sleuths might be a worthy project that somebody a few speakers ago mentioned. Cross reference the FISA warrant footnotes in regards to the linked source proof or whatnot in the FISA documents and applications. That might be worthwhile to go back retroactively and kind of see, compare some of these email chains and the stories that ended up being published to the FISA documents. There might be something there, and I think that is kind of like a worthwhile little project somebody might be able to do. There might be something to that.
And I think that's a good point, and I'm sure some of us will take a look at that over the next couple of days as we sit back and kind of absorb, what just happened and what just dropped tonight. It's certainly worth noting. I mean, the people that are on these communications with Fusion GPS are the worst of the worst. I mean, all the horribly wrong stories throughout 2016 and 2017 came from these guys. And now we know why. I mean, they were in direct contact with Fusion GPS, and they were working at the behest of Fusion GPS. And it's incredible to see, we have New York Times reporters, we have Washington Post reporters, we have Wall Street Journal reporters, we have Slate, and they're working. I mean, they are working with Fusion GPS. There's no other way to say it.
Yeah, they have First Amendment protections, especially because they're journalism outlet and whatnot. But at the end of the day, it's the intent. I mean, did they know what they were doing? Were they coerced? But the last thing I'd like to add is how far back does all this go? Right? I think like before, kind of like the public stuff that Bongino was obsessed about, a long time ago was like the February, March, April timeframe. It was mostly about like Papadopoulos and some of that, hearsay and whatnot, and it was Alexander Downer and whatnot. Now today, we're seeing that this Alpha Bank stuff goes all the way back to February, which is very interesting. So I just wonder how far back all of this goes.
I have not gone through all the emails here. I have not seen anything as far back as February yet. If you have a page number on that, I'd be interested in taking a look at that. But
again, actually, I think it might just be May. I'm sorry.
May. Yeah, May.
I think that's the earliest it goes back.
Yeah, so May.
Talking about Alpha Bank. Yeah.
Yeah, and that obviously that is a little bit earlier than what was previously known, I think. But yeah, we'll take a couple days and absorb this, and I'm sure we'll do another Spaces chat when everybody, when the dust settles and everybody has the time to absorb this. We'll set something up and discuss this a little bit further, and I think this might be a good time to wrap things up here. I know we have a number of other speakers that have requested or a number of people that have requested to speak. I'm sorry if we didn't get to you. I know it's a massive filing, right? And everybody wants to have questions and comment, and I understand that, but it will take a couple days here, and we will set up another call, and we'll be in a better position to actually answer some of those questions, because we're new to it too, so we have to have some time to kind of absorb it. And with that, I am going to
Ryan. Mitch has been trying to get a question in for a while.
Oh, I'm sorry. Go ahead.
Oh, that's okay. Can you hear me?
Yeah.
Yeah, just Margot's tearing it up, man. She's starting to put timelines together. One of her recent ones she just put in was the email from Peter Frisch about Sergey being at KGB on June 27th. So basically, Fusion knew about Sergey before Danchenko told Steele about him. If that makes yeah. So I mean, a lot of this, the time once everybody can get together and start putting timelines to facts, it's gonna be worse.
Yeah, that's a great point. I appreciate you raising that. That's obviously extremely damning, right? And now I want to look more at these Matt Mosk emails too, where they're giving Fusion GPS a heads up that they're going to interview Sergey Milian. I mean, that's, they know that something is going on there, and they're giving a feedback to Fusion GPS. I'll have to check out Margot's feed. I know it's, there's going to be a lot of these threads over the next couple of days. So
yeah, it looks like a lot of this ring circus was run out of Fusion GPS, which we know, but now we're getting confirmation.
Hey, real quick, now that this non-public filing has been accidentally filed publicly, does that damage special counsel's case against Sussman in any way? Like, what can we expect in terms of defense's response or the judge's response to this?
Well, it was an accident, as far as we know, and it is worth noting. I mean, it's an exhibit to a case, so it's not like it was not part of the case. So this, there might be a scolding for John Durham, and King, please correct me if I'm wrong, if it's going to be something more than that. But I don't think there's any risk of anything serious happening. I mean, this was going to be presented at trial, and it's obviously demonstrable of sort of this joint venture conspiracy that's out there. And Fusion GPS, they're talking about Alpha Bank stuff, and they're talking about it with reporters. So they're obviously breaking privilege by sharing this information that they've gathered with reporters. So, I don't think it's going to be too much trouble, but somebody else can correct me if I'm wrong.
Yo, can I share a little hypothesis that I have? I just want to hear King take on this. So basically, I keep reading through this and the timeline's interesting, but like it goes back to the Ratcliffe letter that I was talking about earlier. And basically that just, that talks about that the Russian intel picked up, or they had intelligence that was basically saying that Hillary Clinton approved of this, this ruse basically of Trump tying Trump to Russia, basically with the DNC hack. My hypothesis is that information right now, that conspiracy, what they lay out, is basically tied into privilege, where they, like Durham, can't get those emails or whatever the hell they intercepted, because they're basically tied into privilege. And we've only, our intelligence has only seen what Russia thinks about that. You know what I'm saying? So Durham knows what he's looking for. He wants to get those emails, but he can't because they're obviously withholding him because of privilege, which I think it's actually emails from Fusion to Elias or whoever, which is like sharing Report 95. So I don't know if that's, I guess King just left. Oh, no, he's there. But that's my hypothesis, that Durham kind of knows what he's looking for.
Well, he got it from Ratcliffe most likely, because it would have been in part of the declassified document trove that Trump authorized.
No, that's Russian intelligence, right? Saying what those emails might have said, right? That's an intelligence assessment by Russian intelligence. They don't have the actual emails.
Well, we don't know what they intercepted on the Russian side.
But it's a Russian. Right. No, what I'm saying is it's a Russian intel assessment. Is what they say. They can't say Ratcliffe can't even say if it's true. It's just they know that's what the Russian intelligence assessment is, that Hillary Clinton approved of this. So they must have intercepted something, but our intelligence isn't even sure what they intercepted, because they probably don't have access into the Hillary Clinton campaign, right?
That's a good point. That's interesting. So you're basically you're posing the question. You think, Durham knows there's something there, and
Durham knows there's something there, because it's same thing with the Renteria memo. It's a Russian intelligence assessment of that Renteria was in contact with Loretta Lynch, saying that she wasn't going to let it go very far. But nobody, still to this day, they're we're not even sure if that's true. They've talked to, I think, Renteria and maybe Debbie Wasserman Schultz or whatever about it, and they're denied it or whatever. But this thing is it's different, because my guess is that this is work product. That letter's talking about Russian intelligence intercepting Christopher Steele or whoever, emailing Report 95 to Glenn Simpson or whoever, right? Our government hasn't actually seen those emails because, first of all, it's an intelligence assessment of what might have been intercepted, but also because these guys are claiming this as work product, as privileged information. So what Durham knows is this intelligence assessment exists in Russia, and John Ratcliffe always comes out and he's like, this is not Russian disinformation. This is what they assessed or whatever, right? Because I think they got that from the Dutch most likely. But so Durham wants to get to these emails that actually say this shit, but he doesn't have any access to it because it's probably claimed by privilege.
That's really interesting. I like that theory.
Which, I mean, I haven't really thought about it too much before, but it makes sense. Like that probably, like if they're hiding all this other stuff based on privilege, that probably is hidden on privilege, and we know that our government probably hasn't seen it. And I don't think, because like the way Ratcliffe talks about it, he's just like, we don't know if this is true, but this is what the Russian intelligence assessed that was happening.
Ironic timing for sure.
Right. So I think this like privilege thing, like Durham's talking about like, we want to see what's underneath this, like which there might be nothing, but I think he's searching for something they already know about.
Well,
I like
let me ask a question on that. So there's this Oval Office meeting where that is reported to, this small group of folks up at the top, right?
Yeah.
And we don't have any evidence of what happened after that, but it's not reasonable to think that somebody didn't say, hey, Hillary, what the F is going on here at some point, at some level.
Maybe, or they just looked away from it. I mean, I think they just swept it on the rug. You think any of them would have went like, hey, Hillary, knock it off?
Well, or they helped to facilitate it, maybe.
Exactly, or that. It's not like they... Yeah. Like John Brennan's even like, yeah, we looked at that and it's like, there's nothing wrong. Like Brennan's just like, there's nothing illegal about just spreading lies and rumors and shit like that, which now they're fucking all up on misinformation spreading and stuff like that. But back then, after that letter came out, John Brennan's like, there's nothing illegal about doing that. And I'm like, okay, yeah, you're right. but then taking that information and then giving it to the FBI and trying to start an investigation and stuff like that, that could be illegal. That's the whole defrauding thing. So I don't know if I'm kind of liking this hypothesis. I'm going to have to think about it more. But
Phil, my phone died. What is your hypothesis? I'm back on.
It's basically like just going back to the Ratcliffe letter, which you know what I'm talking about, right?
Right.
Yeah. So basically, like they got a Russian intelligence assessment that Hillary Clinton was trying to tie Trump to Russia and the hack, right?
Right.
So my hypothesis has always been that they basically intercepted, and I think Barr even said this, that it was the Steele stuff, right? So Russian intelligence intercepted Steele emailing 95 or to Simpson or whoever, and Elias or whoever was passing it around. But our government, like Durham right now, maybe has never had access to whatever that intelligence is about, right? He knows like this intelligence assessment by Russia exists, but he doesn't actually have access to those emails because of privilege. So he knows what he's looking for, but because of the Russian intelligence assessment, he thinks it exists, but he probably hasn't actually had access to it because of privilege.
I guess that's possible. We'll just have to wait and see.
Right.
I look at that as a huge black mark on the FBI, because when that assessment came out and Brennan sent it to Comey and Strzok, Crossfire Hurricane was underway. So on the left hand, they're looking at possible evidence that Trump and Russia are colluding. And on the right hand, they have information that needs to be checked out per the CIA, that the Trump-Russia collusion narrative was made up by the Hillary camp to deflect attention away from her emails. So you have to put those two, any investigator would put those two in the same file and check them both out at the same time. That didn't happen.
Yep. That's all I got.
That's good stuff, Fool. I'm glad we talked about that. I think that's really interesting. As I was saying earlier, I mean, we'll set up another chat. I don't know if it'll be, maybe we'll get an indictment tomorrow, in which case we'll definitely do a chat tomorrow. But otherwise, it might be a couple days. We'll set something up and give everybody time to absorb this and see what the fallout is. Maybe this will show up on CNN. That'd be good for a change. But yeah, we'll do this again in a couple days and talk it through. And I appreciate everybody coming out tonight. And I will end it here. Thank you to all our speakers. Y'all are great. And I hope everybody has a good night.
Night.
See you, Fool.
Good night, everybody.
See you
Good
guys.
night.
Right.